One is below the MFA, out of accident of.
No, so I can't. You have to mention it before the suit one.
Sublet. The data appeal your lordship at last week. The lordship indicated that 2 appeals need to be filed.
Ah,
For that, your lordship, we have filed the appeal along with a delay confirmation application. I'm praying for public.
item number. I have so many matters. In 445. What are these? Fix it at 2 p.m. Who? I can't help you. 2014 matter. Yes.
Supplementary item 53 for withdrawal.
Chief, withdrawal of IA number 3835. Was for implement of
Huh?
implement of artificial hospital. In this case, what happened, the plaintiffs filed a suit for eviction of the defendants. That suit was decreed by the work of tribunal. And they filed thereafter one RFA lordship. Thereafter it was
Now what do you want? Yeah.
lordship. In this case,
You want to withdraw.
withdraw the IA lordship.
For what?
As because lordship already
What are you challenging here?
shared
What are you challenging here?
against the judgment of the
You have
court of
filed.
tribunal.
Withdraw.
Lordship, as because
It's okay. Let us dismiss this petition. Your petition. Then matter is over. I'm hearing it. Now tell me, what are you challenging here? Don't prepare. Whenever a matter comes before this court, you have to be ready. What are you challenging? All for the records of so and so. Then and dismiss the suit.
against the lordship.
Now the court has to dismiss under 227.
The judgment is by work of tribunal.
Then
So they earlier they preferred RFA, thereafter RFA was withdrawn and then WPC lordship. That writ was converted to CRP lordship. Now lordship, respondent number 2 and 3, plaintiff number 2 and 3 are again changed lordship. The committee has been changed now. So I have filed, that is the IA, earlier IA 2023 3835. While pendency of this IA lordship, the committee has been changed again lordship. So I have filed IA Civil 609/2025. It is the duty of the petitioner to implead the substituted person's lordship. But I am paying for impleadment and in this.
why you are making the Assam Board of Waqf a party?
plaintiff.
Oh, Waqf Board. They have filed the suit.
My earlier IA is pending and they on last occasion took time to file objection. So lordship, they may raise a question that my earlier impleadment application is pending, so again I have filed another application.
You are appearing for whom now?
For lordship, respondent number 1 to 3, 2, 3 lordship.
So you are appearing now for 2 and 3. And who is appearing for 1?
On Assam Board of Work of lordship.
Who is appearing for it?
That council earlier, Mr. A. Ganguly was appealed.
And 2 and 3?
20 I am appealed.
2 and 3, how is it connected with 1?
Photo board and 2 and 3 to Kotawali and 3 president secretary, both, three of them filed the suit.
Together, they are all plaintiffs.
Yes,
So you have two set of counsels for the plaintiffs.
some board of work of represented by their standing counsel.
Let us hear the matter. You come this way. No, no, no. You're not prepared, I can help you. 227 matters. These are matters to be dismissed right away. What is there out there? What are the lots of things?
But not appointed. There is no authority, the secretary of file. All those things are involved. There is eviction also. There is a procedure of eviction. Also, things are there, but
So you mean to say if the procedure is followed, then you don't need, you have no problem. So no, they would not have any problem. Then it cannot be pending for such a long time, these type of matters. These have come up from 2015. No, no. You want to withdraw this?
The IAL.
Okay, Ms. So-and-so submits and that she would not like to press the instant application. So accordingly, the application stands closed on withdrawal. Next level. A main petition from a taking into account that the matter that the instant matter pertains to an eviction proceedings initiated by the respondent number 1, 2, and 3 in respect to a suit filed in the year 1996. And the matter has been pending before this court for the last for 1 decade. This court fixes this matter at 2 p.m. on Thursday
Public.
for final disposal.
Top of the list, item 1.
Yes,
I have circulated it.
I don't know. Why do you want a circulation?
The adjournment request.
Why?
Chaudhary
Mr. Counsel, should I again put another thing out here that this court does not allow adjournment on senior counsel? Should I put another one here? Then you have been practicing out here. You have seen it in the court out here. I don't grant adjournment on the ground of senior counsel. You have any problem, I will do so, not on the ground of senior counsel. So don't make a submission to them. Now let us see. This matter has been heard by this court earlier. Whether the decree passed in a suit for specific performance of an agreement could be enforced, which involves injury to the property of a third party. Whether demanding refund and acceptance of the advance amount of agreement vitiate willingness on the part of the heir to perform. Whether an agreement is dissolved by doctrine of frustration in the entire performance is becoming. Okay, now tell me what is the case here?
The only thing is
Last
that
time I was about to dismiss, na? Yes. Then
first example of taking this one and but if you take first example, construction of agreement and whether that is and acceptance of money.
yes. In fact, in my opinion, was that these are substantial questions of law which are not at all involved. Okay, let us see the plaint. Let me again recapitulate. You are the plaintiff.
I am the,
You are the plaintiff. They are the defendants.
I'm sorry, ma'am. Yes, ma'am.
You are the plaintiff. Okay.
In trial, it was dismissed. First appellate court.
And measuring size of field in the subject matter of the field. Did the performer defendant or anybody other brothers contested the suit? No. So why does the third question of law arise? First question of law arise? Whether the decree passed in a suit for specific could be enforced, which involves injury to the property of the third party.
But this property was not partitioned.
No, that is a different thing. I'm asking you how the third party question comes in. Third party is not before this court. The third party was a performer defendant, and the performer defendant never raised any objection. So the first question of law does not arise. Now let us keep whether demanding refund and acceptance of the advance money vitiates here. Did you refund that amount?
Yes. The written statement, page 18. Further, the plaintiff had taken back the
Sum of rupees 20,000 paid on remand. The defendant paid back rupees 10,000 by check dated remand drawn on so defendant number Y was present at a few days before the same date. He had taken back 10,000 in cash from the defendant. He took back paid sum by saying that there was need of money for the disposal in subsequent. Now, Is it true before the learned trial court that you have returned?
Page 24.
Now, before the learned first appellate court? How does the learned first appellate court
First
come?
appellate court has decided in negative.
What does it say? Ah, 45. Yes. Confronting the government, I submitted the fee of returning the back in advance for you. Self-flowing. Also feasible the check was every one and then found to Kumar Bora. The appealing, whereas the appealing never received the same. There have been who is Ajit Kumar Bora?
The plaintiff.
And what about the 10,000 rupees, other 10,000 rupees you have returned?
That, no receipt was given by the plaintiff.
So there is no proof.
There is no. But may I-
And during his cross-examination, what happened? Let us see
Commissioner-
the evidence. Record.
may I just first read out the bank manager's evidence first?
No, the bank manager's evidence says that yes, Ajit Bora has received it. There's no quarrel with them. But the question is as to whether the 10,000 was in return, was returning the amount back is the question. And there being a finding of fact of both the courts that it is
Right.
not so.
Right.
Now, the question of law is, once there is an agreement out there, and if there is a return of this 10,000 rupees, without the proof that the 10,000 is a return of the advance, can it be said that the agreement has been cancelled?
Otherwise also, there is no, in cross-examination of the plaintiff, he said he has never met before with the defendant, number one, prior to this agreement of sale. And he has only transaction with regard to this plot of land and this agreement for sale only. He had no other business with this defendant.
No, you yourself in paragraph number 6 say that the 10,000 rupees was necessary for doing something in respect to the execution case. It is your statement in your written statement.
Yes.
Are you not giving the idea behind it?
It was an idea that he was a civil solicitor.
No, tell me, if the plaintiff today has no other business with you except the land, okay, and has an intention for the purpose of purchasing the land from you, let us assume that that is the fact which is mentioned as per the agreement of 14/12/2006. There's no quarrel with that. Now you give a check back to him of 10,000 rupees, wherein you fail to prove that this is a return of the consideration. That is the finding of fact. Now the question arises, you want to say that what was he doing all this time because we had no relation. Are you not giving the basis out there why he has taken the 10,000 in your written statement? Saying that he needed it for the purpose of execution of the decree. It is your admitted stand. Kindly see that paragraph which you have referred to me. Paragraph 6, nah? That is your stand. Why the 10,000 was given to him? Because that amount was required for the purpose of execution of the decree.
In fact, page 18.
No. Kindly see here in your evidence, in your written statement. See at paragraph 8, page 18. Further, he took back the sum of Iman by saying that that was in great need of money and that said disposal and that the disposal of the revision petition and the subsequent execution would take long time. In the execution case number so and so, Emma had taken the inexecutivity of the decree because of omission of some description. As I expressed his mind to cancel.
These proceedings were pending with regard to the suit property.
Let us see the cross-examination. What is this compromise petition? There's a compromise petition done. Another case,
It's
title execution 15,
not related to this case, though.
or that suit land.
That's it. And there is some discrepancy regarding the suit property mentioning of area of land mentioned in the plaint as well as in the evidence of the plaintiff.
Let us see the area of DW1. Oh, God, more.
Lord,
So here you see পদশ তিনিৰ তফচিলৰ বৰ্ণনা কৰা মাটি পাঁচ লেচা মূল মাটি. So when you categorically say that, then how does the first substantial question of law arises? It cannot. And that too at your behest. By two. So here it is being duly admitted as if this is your land. Now you have said that the amount of the sale deed and the agreement for sale was done without your knowledge. The amount was being fixed. Now you have not challenged the agreement for sale. Here you say পদকত তিনিখন কৈছে দিনা কৰিব দিনা বাকীয়ে মোক 20,000 টকা মোৰ ঘৰতে দিছিল যদিও মই টকা পিছত তেওঁক ঘূৰাই দিছিলো. So the check is in his good name,
Check is in the name of the plaintiff.
Ajit Kumar Bora.
Ajit Kumar.
The check is in his. Here's the check. Check was exhibited.
F, F, exhibit F,
Exhibit.
F.
Exhibit A. Ajit Kumar Chandra Bora. Yes, sir.
F1 is the signature of the defendant number 1. F2, signature of the plaintiff.
And this signature proved in original of Ajit Kumar Bora under 73 was identified and has come to an opinion that this amount was being paid to him.
Corroborated by the bank manager.
Corroborated by the-
Bank manager is DW3.
Let's see the cross-examination of the plaintiff.
Yes, he has already, everything he has denied.
He has denied, but you have put that question to him.
Yes. First of all, madam,
No. Did you ask for his explanation anywhere? Did he give any explanation why he took that money? The plaintiff. In his evidence. Yes, Mr. Goswami. Did you give any evidence to the effect why you took that money? Because you denied
he
the
denied.
taking the money. But that aspect has been proved. No. What has happened, the learned appellate court, as I could see, had based his entire case on the basis that he said that in view of the pendency of the suit, the agreement has not been cancelled. That is what he is saying. But that is a question of understanding. But whether by law, if you don't give an explanation to that 10,000 rupees, how?
Amount of, I will say, for the cancellation of agreement. There is nothing.
No, in its chief, he has said that. In its chief, he has said that, DW1. Now, in your cross, you did not put that question, did not put even that suggestion also, that this is not for that. He categorically in his cross says that I have returned him all the 20,000 rupees, 10,000 a year. And you see, ইমান হৈছে যদিও এয়া পদশ তিনিখন সম্পৰ্কন উৎপাদন কৰিবৰ দিনা বাদীয়ে মোক 20,000 টকা মোৰ ঘৰত দিছিল যদিও মই টকা মই পিছত তেওঁক ঘূৰাই দিছিলো মই 20,000 টকা পাইছো বুলি পদশ তিনিখনত উল্লেখ কৰিছিল সত্য নহয় যে মই পিছত বাদীক 20,000 টকা টকা মাত্ৰ ঘূৰাই দিয়া নাছিলো।
In the next page also, my lord, say,
Then he categorically says that I have returned that.
আদিক মই প্ৰথমতে কেছ 10,000 টকা মাত্ৰ চেক দ্বাৰা দিওঁ, অজিত বৰাক নগদ দিয়া 10,000 টকাৰ মাত্ৰ সন্দৰ্ভত কোনো ৰচিদ অজিত বৰাই দিয়া নাই।
Huh?
At the next page, page 4 of the cross examination, in the middle part, আদিক মই প্ৰথমতে কেছ 10,000 টকা মাত্ৰ দিওঁ আৰু বাকী 10,000
আজি
টকা
আজি বাদিক মনত গত দিয়া 10,000 টকা মাত্ৰ
সন্দৰ্ভত কোনো
ৰচিদ
ৰচিদ অজিত
আছিল।
বৰাই দিয়া নাছিল।
So are you not required to give an explanation? Once it is proved that 10,000 has been given. No, in your chief. Are you not required to give something to the explanation? Why did you receive the 10,000? Because he had categorically his case in his claim, he have not said a single word. So he has not said a single word. So you knew his defense. So when you are going to give evidence, you have to say something in your evidence to the effect that this particular amount, although has been stated, but I have not received or they have never mentioned anything to that effect. But the moment that document is proved, and the defendant gives an explanation, you were supposed to give that evidence to that effect. And even you did not cross to the effect that this is not for cancellation, for something else. You didn't put that suggestion also. And the learned first appellate court only went on this particular line that মই গোচৰৰ মই এই বৰ্ণনা দাখিল কৰিছো যদিও পদক 3খন কেনচেল কৰিবলৈ প্ৰাৰ্থনা নাই মনত নাই sorry. I think the black rose is attracting a lot of mosquitoes. We need to have some good pest control. Because I mean, you have a big problem in that. In fact, I think in the CPC, our courts do not follow a particular mode. Now, if you see Order 18, Rule 2, it gives the manner in which the evidence is treated. But the most interesting part is Order 18, Rule 3, which no trial court follows. Here the question is, Order 18, Rule 1 says the right to begin. Right to begin, it is always construed to be the person who has to prove. But what happens in a case where the defendant is to prove? Then the defendant has a right to begin in terms with Order 18, Rule 3. And then the plaintiff he has to give evidence to this. So here the main question is your willingness and anything, but if there is no evidence to the effect, I'll read Order 18 in 3. I think there is this problem which is not being dealt with properly. In fact, we go by the traditional method that the plaintiff will give evidence, the defendant will give evidence, matter will. What does it say? The right to begin is order 18.1. Now kindly come to order 18.2. Order 18.2 gives the order 18 rules. Next time onwards something. So here the case goes in his favor because of that. Number two. In fact, it is not the issue in the substantial question of law should have been whether the finding of so and so is perverse. Taking into account there is no evidence by you. The moment there's your readiness and willingness, but if you don't explain how you received the 10,000 which has been proved, your readiness and willingness goes for us. That is what you should have said that this amount was taken for the proper. You should have put a cross examination to that effect. In fact, you have proved this.
That was put.
It is your thing to give your evidence. You knew his pleadings. See, when you know his pleadings, you know his stand. So are you not required to give your evidence to the effect that we have not received any amount from this 10,000 as stated? Because you are beginning. Either you should have adopted order 18.3, which you did not. But in your chief, you did not. Over. Agreement, it is a misconception. It is an agreement may exist because you say that it has not been cancelled. But the question is, can the agreement be enforced? There are two different aspects, Mr. Rizvi. An agreement may exist, but can it be enforced? If the readiness and willingness is not being proved by you, and they give a rebuttal evidence to the fact that I have returned you the 10,000 or 10,000, whatever it may be, and you have accepted that, your readiness and willingness goes for a 6, so it cannot be enforced by the court. That is the main problem. No, you did not say. You did not say in your evidence that you have received. You should have explained something. It's not a single thread. Hey, suppose you were a prophet. Solution. Sometimes cleaning up the vents of the AC is a problem. It becomes too severe. This area becomes so cold now. They are going to do something. But the problem, Mr. Goswami, is a problem. I tell you, what are your problems? Mr. Goswami, I tell you, where are your problems with that? What are the deficiencies which happen at the trials? You allow the court to go for a 73 examination, which the court ought not to have done it. The question of signature, the court has the power to do it under 73. Court did it, but the normal case of event is that the court should always regard it to the refer it to a specialized agency. He did not challenge it. So thereby, your signature is being proved in this exhibit. The fact that you have received that money can be inferred from there. If you have received, your signature is there, means you have received. Because on the back side, when the signature is being put, you should have said something in your evidence that to that effect. Because that signature was being put subsequently. Prior to that, because that check must have been called for prior at the trial. Prior to that, and the court must have examined it and marked it at that point of time, and later on marked it as exhibits, but kept it on record. So you should have been more careful when you are giving your evidence. You did not say anything on your evidence. You still maintained it about non-receipt of any 10,000, or didn't say a word of that I have to only pay 30,000. Now the question is, once it is a question of 30,000, but you have received the 10,000, but you are asking for only for a decree that you have only liable to pay 30,000. How can there be a, even assuming that you have received this 10,000 here, Means it has to be an amount of 40,000. But where is your readiness and willingness to pay the 40,000? Your entire suit is based on 30,000. So if your readiness and willingness, no, that has to be given a. Mr. Goswami, the question lies like this. There has to be pleadings. If now you don't require, as per section 16C, as of today, you don't require pleading. It's only a proof. So you could have done it. But at that point of time, when the heir was there had to be a pleading and proof, which is absent. The moment this 10,000 is proved and there is no explanation, matter finishes. I can't. This set. There the problem is. But Mr. Goswami, Order 18 Rule 3 was there, not now. It was there then also. It is a very important provision, which normally the lawyers, they do not invoke. That he has a right to prove, I reserve it. I'll do it later. This is not being done. And the trial court also takes it wherever he plainly will prove it. And this, therefore, tomorrow, just for example, there is a counterclaim. A plaintiff gives evidence, other side gives evidence. The plaintiff does not give an evidence in his suit. Okay, the suit may be dismissed because of that. When a counterclaimant gives evidence, then is he not entitled to give a rebuttal evidence? Problem is the trial court does not allow. These are the problems we face when we practice in the trial. This is the provision nobody does. So one day some case will come, I will write some. But as of now, I need to do so. Or you want to wait for Mr. Kane Shodhi now? No, I can allow. Then I may again change my mind on it.
Maybe 1 hour. Fact, there is.
I'm saying, no, Mr. Goswami, my decision is right on the point now. I don't reserve the judgments. One is not there, and what is number 3? Whether an agreement is resolved by the doctrine of person when the entire becomes 3 also does not come into the picture. Therefore,
The same, there is no alternative prayer.
Yeah.
Okay.
or what?
Recovery of money.
That is different. He may not, the council may not know that. Most of the cases they don't. Alternative. They don't go for an alternative take because they know once it doesn't go, so at any point of time they can make a prayer in the plaint in view of order to section 21(5). But that is not beside the point. Let us not. We only have number 2 to decide. Therefore, Mr. A. Dhor, the learned counsel appearing on behalf of the appellant, and Mr. C. Goswami, the learned counsel appearing on behalf of the respondent. This is an appeal filed under section 100 of the Code of Civil Procedure 1908, or short, the Code, challenging the judgment and decree dated 19/5/2012, passed by the learned civil and assistant district judge Jorhat, entitled Appeal number 7 of 2011, whereby the judgment and decree dated 14/2011, passed by the learned Munsif number 2, Jorhat, hereinafter referred to as the trial court, learned trial court, Agoto, hereinafter referred to as the learned first appellate court. In title suit number 11 of 2008 was reversed. It is seen from the reports that by an order dated 4/12/2022, the coordinate bench of this court had admitted the instant appeal by formulating three substantial questions of law. The said are reproduced herein under 1, 2, and 3. For the purpose of deciding as to whether the three substantial questions of law which are formulated by the coordinate bench of this court by the order dated 4/12/2012 are involved in the present appeal, this court would take note of the facts which led to the filing of the instant appeal. For the purpose of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. Next. An agreement admittedly was entered into dated 14/12/2006 between the plaintiff and the defendant for sale of a plot of land which was specifically described in Schedule A to the claim at a consideration of rupees 50,000. The case of the plaintiff is that the plaintiff had paid an amount of rupees 20,000 on the date of execution of the deed of sale agreement for execution of the agreement for sale, deed of agreement for sale. And admittedly, the agreement and the remaining amount of rupees 30,000 was to be paid at the time of execution of the registered deed of sale. It is the specific case of the plaintiff that the plaintiff had requested the defendant to execute the deed of sale and receive the remaining amount of rupees 30,000. But the defendant did not take any steps in that regard. In that regard, a notice was also issued legal notice was issued on 7/9/2007 asking the defendant to execute the deed of sale within a period of 30 days from the date of the said notice. From the date of receipt of the said notice. However, the defendant did not take any steps. It is under such circumstances the plaintiff instituted the suit being title suit number 79/2007 before the court of the Munsif number 1 at Jorhat. In the said suit, the plaintiff sought for a decree for specific performance of the agreement dated 14/12/2006. And thereby directing the defendant to execute and register the deed of sale in favor of the plaintiff in respect to the Schedule A land, fixing a date for depositing the stamp duty, registration fee and the balance consideration of rupees 30,000 by the plaintiff. Semicolon. For and failing which the sale deed be executed and registered by the court in accordance with the provisions of law. Semicolon. A decree for delivery of khas possession of the Schedule A land. Semicolon. Grant of permanent, temporary and permanent injunction. Pursuant to the issuance of notice, summons, next, pursuant to the issuance of summons, the defendant filed a written statement wherein various preliminary objections were taken as regards the maintainability of the suit. It was the case of the defendant that though he had executed the agreement for sale and received the earnest advance consideration of rupees 20,000, but taking into consideration that there was a suit pending for which the sale could not be executed, the sale deed could not have been executed. The plaintiff had approached the defendant for return of the advanced amount. Accordingly, the defendant returned the amount of rupees 10,000 by a check bearing number SB oblique item 055178/407 dated 14/3/2007, drawn on the bank account of the petitioner of the defendant, bearing number 10638597053 with the State Bank of India, 80 Road, Jorhat. The defendant further stated that the remaining amount of rupees 10,000 was returned to the plaintiff by by cash in presence of his wife. Various pleas were taken in the said written statement, but the important aspect for the purpose which has a relevance to the substantial questions of law which have been formulated is that the defendant had returned the amount of rupees 20,000 back to the plaintiff and the agreements to cancelled accordingly. On the basis of the evidence, on the basis of the pleadings, the learned trial court framed as many as 4 issues, which are reproduced herein under page 23. On behalf of the plaintiff, 3 witnesses were examined and 4 documents were exhibited. On behalf of the defendant, 2 witnesses were examined and 6 documents were exhibited. It is very pertinent at this stage to observe that the said check referred to in the pleadings of the defendant was called for by the learned trial court during the pendency of the suit. And the learned trial court, in exercise of its powers under Section 73 of the Indian Evidence Act 1872, compared the signature appearing on the reverse of the said check with the signature of the plaintiff and opined that the signature on the reverse of the said check with was the signature of the plaintiff. For this aspect of the matter was never challenged before any court. It is further seen that the learned trial court, by the judgment and decree dated 14/2/2011, dismissed the suit. While while dismissing the suit, the learned trial court, while deciding the issue number 1, no, তার আগতে লিখো, হ্যাঁ। এইখিনি বাৰু হ'ব, তাৰ আগতে লিখিব, চাৰিটা issue কৰিলো না। It is further relevant to take note of that during the pendency of the suit, an additional issue was framed, which reads as whether the agreement dated 14/12/2006 is a valid one, question mark. It has dismissed the suit. In dismissing the suit, the learned trial court decided the issue number 1, holding that there was an agreement for sale between the plaintiff and the defendant number 1 in respect to the suit land. In respect to the issue number 2, the learned trial court opined that there was no cancellation of the agreement for sale by receiving back by the plaintiff. No, there was no cancellation of the agreement for sale by the plaintiff by receiving back the advance money from the defendant number 1. It is, however, very pertinent to observe that the learned trial court, while deciding the said issue, categorically came to a finding that the plaintiff, had received back the amount of rupees 10,000 from the defendant. The learned trial court, however, observed that there is no material to show that the plaintiff had received the said amount for any other purpose beyond the transaction of the agreement dated 14/12/2006. And the defendant had successfully discharged his burden of proving that the plaintiff received back the rupees 10,000 out of the advance amount paid to the defendant. However, on the ground that there was no documentary evidence to show that the agreement dated 14/12/2006 was in fact cancelled, the receiving back of the advance amount was held by the learned trial court would not amount to cancellation of an agreement for sale. Next. In respect to the issue number 3, the learned trial court observed that the plaintiff was not entitled for specific performance of the contract on the ground that the plaintiff have received back the amount of rupees 10,000 out of the advance amount paid to the defendant. And from the conduct thereof, it can be discerned that the plaintiff was not ready and willing to perform his part of the contract. In respect to the issue number 4, the learned trial court observed that the plaintiff was not entitled to any relief. The learned trial court, however, did not decide the issue number 5. The defendant herein, being aggrieved, preferred an appeal. Now, the plaintiff herein, the plaintiff, being aggrieved, preferred an appeal, being titled Appeal number 7/2011. The learned first appellate court, before the learned first appellate court, the learned first appellate court, however, allowed the appeal by the judgment and decree dated 19/5/2012. The learned trial court, while deciding the issue number 2, observed also came to a finding of fact that the plaintiff had taken the amount of rupees 10,000 back from the plaintiff defendant. But on the ground that there was no bilateral agreement specifying the receipt of the amount for cancellation of the agreement, the learned first appellate court held that on that basis the agreement cannot be said to have been cancelled. In respect to the issue number 3, which is of vital importance, taking into consideration that the learned trial court had decided against the plaintiff, the learned trial court first appellate court came to a finding that the plaintiff not only averred in his claim that he was ready and willing to perform his part of the contract to get the sale deed executed in terms with the agreement dated 14/12/2006, but also proved through PW2 and Exhibit 4 that the plaintiff repeatedly approached the defendant for enforcement of the contract to execute the sale deed, offering his readiness and willingness to perform the part of the agreement. The learned trial first appellate court also observed that the agreement dated 14/12/2006 was still in existence and accordingly enforceable. And on that ground, differed with the decision of the learned trial court and held that the plaintiff was entitled to for specific performance of the agreement. The issue number 4 accordingly was decided in view of the decision rendered in issue number 3, thereby granting the reliefs as was sought for by the plaintiff in the suit. being aggrieved the present appeal. In the backdrop of the above, let this court now take note of the three substantial questions of law as formulated by the learned counsel, by the learned ordinance bench of this court by the order dated 4/12/2012. This court has heard Mr. A. Dhar, the learned counsel appearing on behalf of the appellant who submitted that taking into account the evidence on record, the substantial evidence on record wherein the defendant have duly admitted, the defendant oblique the appellant herein have duly admitted that the land in Schedule A land is specifically the land belonging to the defendant. The substantial question of law formulated at serial number 1 and 3 would not be involved in the instant appeal. This court have also taken note of the evidence of the defendant, who was the DW1, who had also categorically stated that the Schedule A land was the land which fell to the share of the defendant, and the performer and his brother had no right over the Schedule A land. Considering the above, this court therefore is also of the opinion that the substantial question number 1 and 3 does not arise, they are not involved in the instant appeal. First, no, 1 is not. 1 and 3 not. 1. It 1 heck over. In the backdrop of the above, let this court now take up the substantial question of law, the substantial formulated number 2, substantial question number of law at serial number 2, as to whether demanding refund and acceptance of advance money of the agreement vitiate willingness of the party to perform the obligation of the promise. During the course of the argument, the counsel appearing on behalf of the appellant submitted that the fact that the appellant have duly returned the defendant of the defendant having duly refunded the amount of rupees 10,000 have been admitted is a finding of fact arrived at by the learned first trial court as well as the learned first appellate court. He therefore submitted that the learned first appellate court erred in law in deciding on the issue of enforceability of the agreement dated 14/12/2006 in the touchstone of section 16(6)(c) of the Specific Relief Act 1963. Mr. A. Dhar, the learned counsel, further submitted that the plaintiff herein did not adduce any evidence, did neither plead nor adduce any evidence to that effect as to why the amount of rupees 10,000 was received back by him. The evidence of the plaintiff, the evidence of the defendant, however, was clear to the effect that the amount of rupees 20,000, out of which rupees 10,000 was paid by check, was returned to the plaintiff on the ground that the plaintiff wanted for cancellation of the deed of sale, of agreement for sale. the evidence in chief, as per the learned counsel appearing on behalf of the appellant, could not be dislodged during the cross-examination of the defendant. The learned per contra, Mr. C. Usami, appearing on behalf of the appellant, submitted on behalf of the plaintiff, submitted that the respondent that the burden was upon the defendant to prove that the said amount of rupees 10,000 was returned on account of cancellation of the deed of sale agreement, which both the courts below, while deciding the issue number 2, came to a categorical opinion that the said amount was not returned. That there was no proof that the defendant or the plaintiff wanted the cancellation of the deed of sale agreement for sale. Read your submission. I've heard the learned counsel of the which one? No, that is not the question. You should have explained the moment it is proved. You have to explain something because we go as per the, what do you say that? Probability, what is that? Balancing the probability. Go on, but the fact that you see, what is your evidence? That I have not received a single penny. That's your evidence. But the fact that you have received the 10,000 is proved. Then how do you explain that 10,000? Where you are only saying. No. They have said that we have returned you. You have to explain that. They have returned. They say why they have returned you. And you could not break that evidence. Supreme Court name. Upon hearing the counsel's appearing on behalf of the party on this substantial question of law, so formulated, the issue which arises before this court is as to whether the plaintiff had readiness and willingness to perform his part of the contract. From the finding of fact arrived at by both the courts below, it is clear that an amount of rupees 10,000 was received back by the plaintiff from the defendant. The defendant in his evidence that the plaintiff continued to pursue his stand that the plaintiff did not receive any amount back from the defendant. On the other hand, the defendant, by way of his evidence, have proved before the learned trial court, as well as before the learned, by way of his evidence, have proved that an amount of rupees 10,000 was returned back to the plaintiff, which has been the finding of fact arrived at by both the courts below. In view of such a finding of fact, it was the duty of the plaintiff to explain as to why the said amount of rupees 10,000 was received back by him. This court further takes note of that in absence of such an evidence to the effect, the readiness and willingness of the plaintiff to perform his part of the contract the aspect pertaining to readiness of willingness of the plaintiff to perform his part of the contract cannot be said to have been proved. It is also to be noticed that in the suit, the plaintiffs have categorically stated that he is ready and willing to pay the remaining amount of rupees 30,000. In the evidence, the plaintiff continued to maintain his stand that the plaintiff is ready and willing to part with rupees 30,000. Even during the first appellate stage or before this court also, there is no additional evidence being brought that the plaintiff is willing to part with any further amount beyond rupees 30,000. Considering the above, it is therefore the opinion of this court that the learned trial court was justified in arriving at the conclusion in respect to the issue number 3 that the plaintiff could not prove his readiness and willingness to perform his part of the contract. Consequently, the substantial question of law so formulated, the second substantial question of law so formulated in the opinion of this court duly arises, is involved in the instant appeal. Coming to the third substantial question of law, the second substantial question of law is involved in the instant. Coming to the third substantial question of law which have been formulated as to whether the agreement is dissolved by the doctrine of frustration when the entire performance of the agreement becomes substantially impossible. In the opinion of this court, cannot be said to be a substantial question of law involved in the instant appeal. The reason being that the doctrine of frustration is neither pleaded nor there is any evidence adduced, nor and additionally, it does not form a part of finding of facts by the learned courts below. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Santosh Hazare versus Purushottam Tiwari, reported in 2001 3 Tiwari, and paragraph number 14 of the same judgment is reproduced here in under. In view of the above analysis, it would therefore be seen that the second substantial question of law is involved in the appeal. As such, the impugned judgment and decree passed by the learned first appellate court, dated so and so, set aside, and this court restores the judgment and decree passed by the learned trial court, dated so and so. Appeal stands allowed. Accordingly, the appeal stands allowed to with cost stands allowed. Return also.
Maybe, Lord. On the last occasion, my life, after before Lordship, actually, the claim, the respondent, they are claiming, Malad. They said, he has received the compensation amount, says by the local revenue authority, Malad, who are tool and financial section of the legislature. If that is the position, Malad, what is the question of the preparing this petition under section 16(3), Malad, before the learned decide, this is a higher animal. But over and above, Malad, the petition filed by the respondent number 3, Malad, is marked by limitation, Malad. Because beyond, it was filed beyond time, Malad. At that point was not the never, this learned, edition, this has not framed any issue, Malad, on that point, Malad. For that, actually, I may be permitted to refer to the, reaching the objection filed by the opposite party number, my lord, 1 and 2, that is any TC, my lord. That we will find a page 24, my lord, of the petition. That point was especially clear before the court, my lord.
Mr. Das, first, let us take up CRP 68/2000.
That way, sir.
Now, this is an application filed under 710G.
Petition, my lord. No, 10, my actual 3, my lord. 10 and 16, my lord.
10 and 16. He has asked for how much? 65 lakhs.
They demanded 68 lakhs, 8,956, my lord. As against that, they, by the equal judgment, my lord, then amount of rupees 3,14,470 has been awarded, my lord. These these 2 points, my lord, about the limitation, my lord, and also they are full and final submission, that no point was raised, my lord, formulated by the learned additional procedures, my lord.
Regarding
Clearly about the limitation, point of limitation, my lord, and also and the amount received by the claiming, my lord, towards full and final satisfaction, my lord. On
this
two
is
grounds,
an,
my lord.
let us see the provision. Telegraph Act. Telegraph.
Still got it.
No, no, Telegraph.
I can read my book, my lord.
Ten. Telegraph
Chapter 10,
authority may from time to time place a pressure in. We are concerned with 16.
16, my lord. 16 by 16, 3, my lord.
Any dispute arises concerning the sufficiency of compensation to be paid under the Constitution. Well, on an application for that purpose by the where is the limitation mentioned?
They said no, there you had mentioned about the period of limitation, my lord.
Then?
Then in that case, my lord, the article 137 will apply, my lord. Of the limitation act, my lord.
The right to apply,
That's it, sir.
apply to. When would the right to apply accrue?
On after receipt of this compensation malot, last the date of receiving the compensation amount malot.
When did they receive the amount?
That actually that in between the 2011 and 2012 malot. That especially we have stated in our in the written objection malot.
When did they receive it?
That malot. Page 26 malot.
Petitioner received the service damages compensation in the year 2012 through Axis Bank check and filed the petition long after 3 years of the receipt of the compensation with the ulterior motive. Article 137 stipulated that the time for such claim is within from the date of receipt of the compensation. Claimants received the compensation without any objection and thereby the same year afterthought and death. So it is only on the point of limitation.
Limitation and also about whether that amount received by the claimant is full and towards full and financial satisfaction. After to that also that there no point was formulated by the planning additional Caesar. We have said in a written objection that he has received the amount, compensation amount towards full and financial satisfaction. If therefore there should not be any application. Claiming a company.
Did you give adduce evidence?
Hello.
Did you adduce evidence?
No, actually, we have not laid any evidence.
So then if you don't adduce evidence, no, if you don't adduce evidence, how will anybody know that they have received that amount on such and such date?
But in our objection, we have said that, madam. Basically, we have said that.
No, you should have adduced evidence. Because the burden is on you. Then how does the limitation actually apply? Because you see, you are bringing 137 out here saying that 3 years from the date of receipt of the compensation. Did you prove that they received the compensation on that date? And that too without protest? Did you prove that?
We have not laid any evidence to that effect, madam. She has accepted this filing this objection, madam. It's in the objection, madam.
That is over. You should have reduced evidence.
Let them go back to that.
No.
Madam.
This is already 2016, Mr. Das.
Madam.
Now we are, how much amount has been given? Not much.
By the input order, the judgment malot 3,14,470, madam.
No, how much? Nothing much. For you, it is not.
Initially, but originally the assessment was made by the local revenue authority in presence of the claimant malot.
They have proved these.
Malot.
They have proved these aspects.
Well.
The learned trial court
Well.
has come to an opinion on the basis of proof. Whether the compensation paid to the area in support of this kind of petitioner has adduced evidence personally and to the officials of the Agriculture Office and the Forest Department who have submitted the relevant data showing the prices of so-and-so in 2000. In the case it is admitted by the layer that the 3 numbers of that tree, so-and-so, so-and-so, so-and-so. In the case it is admitted by the opposite party that there are 3 numbers of jackfruit trees, 20, so-and-so, so-and-so. Okay? Totaling amount to year. Total therefore did not pay the actual compensation amounting to so-and-so. Demand in view of that jackfruit 90,000, so-and-so, so-and-so. So-and-so cauliflower plantation, a sum of rupees demand admitted. Total is demand. And how much minus? You have paid some amount has been minus.
He has received malot 95,122.
Already paid shall be deducted from that amount. So this is there. No case.
No, only one of my.
Your case are two. First, 137.
Right.
Secondly, on the ground of that they have received it without protest.
Right.
Now, without protest, you have to prove it.
Right.
It is your duty. Secondly, the dates on which they have received the compensation, you have to prove it.
No, only my lord's question,
on the basis of the pleadings, my lord, the learned additional district judge ought to have been framed the point of like the point for giving the decision, my lord, on the particular.
Why didn't you file an application there? That why didn't we want this issue? Did you file any and make any attempt to that effect? No.
No.
Then nothing even.
Just time the page, my lord, the learned,
As a simple matter.
it's page 37, my lord. Issues, my lord, issues framed by the.
I understand. When the issues were framed, you knew about it. Then why didn't you file an application? Huh? That it is barred by so and so. You should have filed an application. You did not. How can I help you?
No, I don't deep paid learned.
I can do only one thing. I want to good favor to you.
Right.
The interest will only run from 2016 when they file them. That is the only good thing I can do. Nothing more than that.
No, here in this case, what happened in this learned additional decision by the same additional decision, my lord, in another case, my lord, dismiss the petition on the ground of the limitation also, my lord. That I have annexed, my lord, the judgment. But the same judge, the additional decision, my lord.
That is the reason why the Constitution does not confer them 215 power. They are therefore not court of records and bound. We are otherwise bound.
After all, these are public money, my lord, public money, my lord, they are
Public money, everything is understood. But the thing that the fact that these are all admitted, you should have given evidence. Why haven't you given evidence? And the money is not so much. Yes. I can only do one thing for you is that interest will be calculated from the date on which they filed. Okay? Very well. So I dispose all by one common judge. Who died?
separate respond, my lord. The claimant, my lord.
No, that I will take it out. That I will say that he has died, he will inform and he will take appropriate steps. Rest I dispose it of, only on these 2 points.
So, may I say before the lordship, my lord, let the matter be limited back to the learned additional decision, my lord, for framing it.
No, nothing we are. No, Mr. Das, 2016 matter, we are in 2025. It will be, you will be at the end because this will not deserve any justice.
No,
I'm not going to remand it back.
What we
Now only thing, now argue Mr. Das. You see, there is one option. Without making it 28 also, I can dispose it of. If I dismiss all your matters. I'm not passing any order against the dead person if I dismiss. So should I dismiss all or should I give you the benefit of interest from the date you have filed? Option is yours.
Additional decision, but
There is nothing wrong. First, there is no period, no limit.
No, only this.
The moment you bring in 137, it is your duty to prove that. In a recent judgment I have passed.
No, my lord, on the basis of this pleadings, my lord, pleadings of the parties, they are learning the additional decisions of having the framed these are issues, my lord, on this particular matter, my lord.
You see, first of all, this, if I was also there, I would not have framed that issue considering the fact that you did not, barely saying 137 would not do. 137 is on a different thing. It does not say from the date on when you have received the compensation.
No.
When the right to apply accrues.
Yes.
So you are to therefore prove
No, the only thing, but
that the right to accrued on the date on which he had been notified about this compensation, and this is the date on which he had been notified. And once that is being done, then 137 will come. And for that you have to prove. You have not proved it. Now, if I give it back, the thing is that you are going to do the best. Yeah. So I think interest also should not touch. Yeah. Okay. This isn't taken. No. So no interest. I think all should be dismissed. No touching on interest. And I am 227. Supervisory should I exercise on. Check. Oh. I heard Mr. NC Das the learning senior counsel assisted by so and so. Wait, let me first put the name of the petitioner. I know it. I'll put your name in golden letters. Golden advisory computer to learn. And then it's senior counsel assisted by so and so. Mr. So and so appears on behalf of the private respondents. And you appear for the state of Assam. Mr. A.K. Vachati appears on behalf of state of Assam. Mr. So-and-so, the learned counsel submitted that in respect to which item number 48 is what, 28? That he appeared, that Mr. So-and-so appears for the respondent numbers 1 and 2. Mr. So-and-so appears on behalf of the claimants who are the private respondents in the instant proceedings, except in CRP number. What is that CRP? 95/2023. Right. All these applications, all the applications are taken up together. All are same date. Disposal.
No, madam, they are different cases, my lord.
If I would take the date.
The 60th, my lord, that is judgment, my lord.
It's okay.
That was 15/7/2022, my lord. All by the
That's
land.
okay. Taking into account the issue involved, the grounds on which the present applications are filed invoking the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution. This court takes up all these applications together for disposal by this common judgment and order. For the sake of clarity, this court would give a brief detail of the challenge made in the instant applications. First, we go. Take the CLE. CRP 60, item number first is CRP 61, where's 68,
68, my lord.
68 of 68 of 2023. CRP 68 of 2023. Take a look, 61 of a look, huh? No, 68 of 68 of the 2023. It will heading for full letters underline. In the instant application, the petitioner herein have said the order passed on 19/9/2022 passed in Miss PG case number 42/2016, whereby an amount of rupees 3,14,470 along with interest at the rate of 6% per annum from the date of filing of the petition was awarded as the compensation under section 16 of the Telegraph Act 1885. It was further observed that the amount so directed to be paid, it was also observed that the amount already paid shall be deducted from the total amount payable to the claimant. First. এইটো এনেকে আপোনালোকে পাৰিব ন, মই কৰিব নালাগে ন? Mr. MC Das, the learned senior counsel, in the backdrop of the challenge noted above, in the backdrop of the challenge made to the impugned orders in the various proceedings noted above. Come on. Let this court take note of the submissions made by the learned counsel appearing on behalf of the petitioner. The case of the petitioner as submitted by Mr. N.C. Das, the learned senior counsel, is that the learned additional district judge Hailakandi, who is the authority in terms with section 16(3) of the Indian Telegraph Act 1885, for short the Act of 1885, did not decide that the applications so filed by the claimants in all claimants under section 16 of the Act of 1885 was beyond the period of limitation. Mr. N.C. Das, the learned senior counsel, submitted that though section 16 of the Act of 1885 do not mention any period of limitation But by virtue of Article 137 of Schedule 3 to the Limitation Act 1963, for short, the Act of 1963, the period of limitation would run from the date on which the limitation act, the date on which when the right to apply accrues. The Learned Senior Counsel submitted that the right to apply accrued upon the applicants, upon the claimants, immediately upon receipt of the compensation, which was more than 3 years prior to filing of the applications under Section 16 of the Act of 1885. The Learned Counsel, Senior Counsel, further submitted that the claimants have also received the compensation without any protest. And as such, the claimants had no right to file the application under Section 16 of the Act of 1885. This very aspect of the matter was also not taken into consideration by the learned Additional District Judge Hailakante while deciding the various cases, while deciding the various applications. While passing the impugned orders in the various applications filed under Section 16 of the Act of 1885. Per contra, Mr. So-and-so, appearing on behalf of the claimants, submitted, public the private respondent, submitted that Article 137 of the Limitation Act prescribes a limitation of 3 years from the date on which the right to apply accrues. He submitted that the dispute arose when, in spite of submission of representations to the authorities, they have not paid any heed to the claims of the private respondents, of the claimants. And as such, the right to accrue applied on such representation not been taken note of. He further submitted that in the impugned orders, it would be seen that this very aspect had been duly dealt with by the learned court of the Additional District Judge Hailakante. In addition to that, the learned counsel also submitted that the learned court had also taken due note of that the claimants herein are rural people and might also not know the technicalities of the legal principles. Yes, you wanted your name to be put on the first. What is your submission? Don't come up with a submission, you have nothing to say. Not you, they. Yes. No, I'm saying about this. What is wrong with this one? No, there's no reference here. This is not a reference. This is an application to. This is unlike a reference. Reference is be done by the DC. This is not a reference. But this is an application to. So what do you say about Article 137? But they have raised it in their written objection. Period of limitation. And it is a beneficial. It is, don't you think that it is a beneficial and a welfare legislation like the Land Compensation Act? No, we are not concerned. Mr. Vatsarji, we are not concerned with all other aspects. Simple issue. One concern. Don't you think that Section 16 of the Telegraph Act, it seems to be parametered here with the National Highways Act, parameter with the Land Compensation Act, the Land Acquisition Act. Because here you are acquiring some right over the land, maybe over the area by which this area becomes unusable. When you put the transmission wires on top, you can't use the any area below because it will get burned and people can't go there. So these being beneficial legislation, well, beneficial and welfare legislation, the interpretation how it is to be given should be in a more okay, let me summarize the argument in this judgment. The KK virtually appearing on behalf of the government of Assam submits that the provision of the Act of the provision of Section 16 of the Act of 1885 is a beneficial and a welfare legislation for the benefit of those persons who have been deprived of the use of their own land. He therefore submits that they are entitled, the persons concerned who are actually entitled to the compensation should be given the fair, just and fair compensation. Anything more? Their compensation rather than rejecting their claim on technicalities. First, I've heard the learned counsels appearing on behalf of the parties at length, and given my anxious consideration, the court have also perused the LCR, the lower court records, which have been called for by this court. For deciding the issue, for deciding the contention so raised, it is relevant to take note of Section 16(3). Sixteen three, 16(4), and 16(5) of the Act of 1885, which is reproduced hereunder. From a very perusal of Section 16(3), it will be seen that if any dispute arises concerning the sufficiency of the compensation to be paid under Section 10, Clause D, an application can be filed to the district judge within whose jurisdiction the property is situated for determination as regards the sufficiency of the compensation. In terms of subsection 4 of Section 16, if any dispute arises as to the persons entitled to receive compensation or to the proportion in which the persons interested are entitled to share in it, the Telegraph Authority, or in the instant case, the appellant, the petitioners herein, would be required to pay the said amount in the court of the district judge, such amount as the authority deems sufficient, or where all the disputing parties have in writing admitted the amount tendered to be sufficient, or the amount has been determined under subsection 3, that amount the district judge, after giving notice to the parties and hearing such of them as desired to be heard, shall determine the persons entitled to receive the compensation, or, as the case may be, the proportion to which the persons interested are entitled to share. In effect, subsection 4 of Section 16 relates to objections relating to the objection as to the person interest, as to the persons who are entitled to the compensation, or the apportionment of the compensation amongst the persons interested. It is very pertinent to mention that in subsection 4 of Section 16, there is a reference that the amount which is required to be deposited by the authority who is acquiring the land either has to be admitted in writing to be sufficient or such amount which have been determined under subsection 3. Of section 16. This aspect is relevant in as much as this would be, this aspect is pertinent as there is a requirement as it appears. Now, this aspect is pertinent, which should be seen at the later stages of the instant judgment. In terms of subsection 5 of section 16, every determination of a dispute by the district judge under subsection 3 or under subsection 4 shall be final. Let me come back. 2 o'clock. But it stipulates that every determination of a dispute by a district judge under subsection 3 or subsection 4 shall be final. It will be seen from a very perusal of section 16 of the Act of 1885 that there is no mention as to when an application is required to be filed, as to within what period an application is required to be filed in terms with section 16(3) of the Act of 1885. It only stipulates when a dispute arises. In the backdrop of the above, let this court take note of the submission of Mr. N.C. Das, the learned senior counsel appearing on behalf of the petitioner, who submits that in terms of section 130, article 137 of the Act of 1963, the period of limitation would be 3 years from the date on which the compensation was paid to the petitioner, to the claimants. This court have duly taken note of Article 137 of the Act of 1963, which stipulates that the period of limitation would start when the right to apply accrues. Under such circumstances, if Article 137 of the Act of 1963 is conjunctly read with Section 16(3) of the Act of 1885, it would therefore be seen that the right to apply and file the application would arise only when there is a dispute which has a reason for determination as regards the insufficiency of the compensation. The limit court of the additional district judge Hailakandi, in the impugned orders assailed in the present batch of petitions, applications have duly taken note of that the claimants have represented before the authorities concerned as regards the insufficiency of the compensation. And these representations and the issuance of these representations were not denied by the petitioner. The non-consideration of the representations have led to the accruing, had led to the dispute. And it is under such circumstances the applications were filed under section 16.3 before the learned district judge, Hailakandi, which was transferred to the court of the learned additional district judge Hailakandi for its disposal. This court further finds it relevant to take note of that the respondent here, the petitioners herein, had an opportunity to adduce evidence, but no evidence was adduced except merely stating that on certain particular dates the amounts were received. Considering the above, this court is of the opinion that the learned additional district judge Hailakandi, while passing the impugned orders, have duly taken note of section 16.3 of the Act of 1895. This court further also, and additionally, this court also finds it relevant to observe that section 16.3 is a beneficial as well as a welfare legislation. Aimed at determination of determination of the just and fair compensation. The learned, taking into account the above, this court finds no ground for interference in the respect to the said submission as regards to the effect that the proceedings filed under section 16.3 was barred by limitation. The next submission so made is that the claimants have received the amount and did not without any objection. And as such, the applications so filed under section 16.3 of the Act of 1885 were not maintainable. The said submission, in the opinion of this court, is misconceived on two counts. First, Section 16(3) do not stipulate a bar to file an application seeking sufficiency of compensation. Insufficiency of compensation. Seeking determination of the sufficiency of the compensation. Unlike the second proviso to Section 31 of the Land Acquisition Act 1894. Secondly, the petitioners herein did not produce any evidence that the claimants have received the amount, have admitted in writing the amount tendered to be sufficient, which would be seen in subsection 4 of Section 16. The reference to which this court had made in the previous sections of the instant judgment, segment of the instant judgment. Considering the above, this court finds no ground to exercise the jurisdiction under supervisory jurisdiction against the impugned orders assailed in the instant proceeding in the batch of writ petitions. In the batch of applications. Accordingly, the petitions none dismissed. However, in the facts of the case, this court is not inclined to impose any costs.
For a rate of interest,
That is already given from the date of filing of the application. So nothing is there. So that interest is.
Case number, item number 26, 26 to 36, there is a petition filed by the Power Grid Corporation, In that case, actually, the Power Grid Corporation, they have not executed the work, because the work was executed by the NETC, They are, with the rights of they are given to the NETC, for making payment, There is a clear stand taken by the where any Power Grid, in their written statement,
Which matters?
Item number,
Did you raise that issue before that?
not only the, my only
No. Did you raise that issue before that court?
only objection, written objection filed with
No. Did you raise that issue before? No. Did you take that in your written objection? That the Power Grid Corporation did not. Before parting with the record, this court finds it relevant to take note of one submission made by Mr. N.C. Das, the Senior Counsel. That in which are the items? In
26 to 34, some item number 26 to 34.
26 to
34.
in number ikita CRP numbers so and so. Yar din kita others base cases asin heard. Submits that in respect to these cases, kita number zero. Itu apne CRP number itu nidibo in list easy case number. You give the details which are there. So and so. 26 to 34.
34.
34. The Installation of the wire line. Installation of the transmission line.
Overhead transmission line.
Overhead transmission line was not done by the Power Grid Corporation of India Limited, but rather it was done by,
NETC madam.
what is that?
Not Eastern Transmission Company Malay Limited. Not Eastern Transmission Company Limited. madam.
And as such, the imposition of liability upon the petitioner was not proper. This aspect of the matter, in the opinion of this court, can be agitated by the petitioner before the learned court of the so-and-so
Additional district, that's what Hailakandi.
by filing a review application. In that regard, this court grants 30 days of time to the petitioner to avail such remedy if so advised.
Published.
Item 54.
Yes, Miss Todi. When are you vacating?
So he's outside only, I'm just calling. He has the instructions.
Huh?
Mr. Sahiwala, sir, he's outside only, sir. Doctor, I'll just call him, he has the instructions.
Okay. One piece of money. Two.
Item 55.
Where is Mr. Samaria? Yes, Mr. Samrali, your matter, item 2.
Item 2.
What is it, concurrent? Mr. Is it concurrent?
Also concurrent, but some facts, important facts, lordship has not been considered.
Huh?
Important facts, which is actually in the form of evidence, it is on record, that has not been considered. Say, your lordship,
No, is it concurrent on both counts?
correct.
Both counts.
Now, your lordship, his allegation is that since December 1998, I am defaulted. During cross-examination, he has admitted,
Forget about the defaulter. What do you say about bona fide?
he has admitted
No, what do you say about bona fide requirement?
bona fide requirement, your lordship, as he could not run the business, your lordship, his father could not run the business, plaintiff's father. So, in consultation with his father, the plaintiff, your lordship, made the hotel, your lordship. Hotel means, your lordship, it is like laws. Not as such hotel, your lordship, it is a law. And the house is very old. And it was not actually in fit condition to run in either lodge or hotel.
So they'll break it.
So no, your lordship, I spent a huge amount of money.
So
With
who
the
has asked
consent.
you? Were you permitted by him to spend that amount?
With his consent, your lordship, plaintiff's
Show me
consent,
where is the proof
lordship,
that with his consent you have invested such amount?
lordship, there's a 5 lakhs about it.
How much? How did you do it? With his consent.
But
Where is the consent? Where is the proof?
so it is a Harvell, your lordship.
Huh?
Arrangement was Harvell, your.
No,
It is not in writing.
no case.
It was Harvell.
So only on that ground we have to go. So when are you vacating?
And that, your lordship, that amount actually he should refund us, your lordship. That expenses we incurred, your lordship, that is 5 lakhs plus security amount. That security amount, your lordship, it has been,
And you made the repairing work in the year 2003. And you took the permission from the landlord who died in 1998. Fantastic.
no, 2003, your lordship.
But how much is the cost we should impose now?
No, your lordship.
No,
this
dismiss
the
to dismiss. How much is the cost?
Cost is not. actually
5 lakhs.
Matter here, lordship.
No, 5 lakhs.
Lordship. this-
5 lakhs, Mr.
No, no,
Mukit, would it be
Lord,
sufficient for the
Kindly
cost?
kindly listen with that, lordship.
Dismissal of this petition with cost of 5 lakhs? Then,
Lordship, kindly listen with your lordship.
no,
So far,
nothing.
I am
is there.
also not in a position, your lordship. to
Amount
grant
is
it.
lying with the landlord as security deposit. Accordingly, the issue is decided. I am not on that question. Security
Now,
deposit.
your lordship will find in the degree.
We are on the question of
the appellate
bona
court.
fide requirement. Where is the finding? Is the finding?
At
Issue
least
number
your
well,
lordship will count.
which so and so
61.
has a suit for legal court or not given if you know. Not in that. So, vessel has a right. Where is the bona fide requirement issue? Issue number? Where is the AI issue? Let us not go in unnecessary legal. Yes, issue number 5. Stated in his evidence that on and from the year 1993, he had been looking in the sphere and was running the same in the name of retail industry, and for that purpose obtained the trade license. He stated that he is a bona fide requirement of the law for his use and occupation as well as the occupation of the party. He had the status that he is several times. And but another judgment. So on bona fide requirement, you make it. When? How much time?
Lordship,
How much time?
lordship, if time is given, lordship, 1 year, lordship minimum.
Maximum I can give you is 6 months.
6 months.
Subject to an undertaking being given within 10 days before the trial court that you are going to vacate. Within on or before that date, you are going to use this particular thing as a custodian of the plaintiff and shall not create any third party interest or right over that property or anything which is detrimental to the interest of the plaintiff. And number 3 is you are going to pay, how much is he paying? 18,000 per month as a form of a compensation during this period of 6 months. And on making of such payment shall not create any landlord-tenant relation. This is the undertaking you have to give, and then you can.
Lordship, here about.
No, Mr. Ali. This is the order.
Lordship, you are the appellate court and the first appellate trial court, same court, your lord. That is one defect, your lord.
What?
Trial court and the first appellate. The same court, your lord.
How?
Is your lordship, the matter was actually, first appeal was filed before this honorable court,
Before that?
before the high court.
Ah.
When the pecuniary jurisdiction of the court hence your lordship before trial court, so it was sent back to the civil judge to your lord. And civil judge to was the trial court also.
So who passed the decree, initial decree?
Initial decree of civil judge to your lord. Civil judge to your lord.
Huh?
Civil judge to.
Mr. Mukit? Then this is a cost of 5 lakhs.
Huh?
You pay that. You have to pay how much? 2,50,000, na?
2,50,000 your lordship.
Is the security. You do one thing. Huh? No, you do one thing. within the 2,50,000 and take from it another 2,50,000, which is the imposition of cost I'm making.
Lordship, this amount, your lordship, it is
No,
fine
no,
for
no.
that. So lordship, whatever, since 96,
Let us dictate.
696,
No,
they are
Mr.
enjoying the
Ali,
on
let
that.
us dictate. This is a case, these cases should be finished on the first day itself. There is no second day these type of matters should be.
Lordship, since
2024, we are in 2025. How many?
696, your lordship, they have enjoyed the
You,
amount, your lordship.
no, Mr. Ali, are you going to say therefore that a person who has entered into a tenancy agreement has a right over the building? No,
At least some interest should be given, your
no
lordship,
interest. What interest?
because under the exhibit one, your lordship,
No, no, the interest which is there is this. I'm therefore deducting the 2,50,000. I'm asking you to pay an additional 2,50,000 because the 5 lakh is the
Lordship,
cost.
actually, what happened, your lordship, that 250,000, your lordship, they have actually invested, your lordship, they have enjoyed, your lordship. Since 1996 till
You vacate within 6 months, you get that amount. 2,50,000.
that may be
Was
refunded.
was it at any point of time there was any agreement that there will be an interest?
No, there is no mention of interest, but there is no mention that without interest, it will be enjoyed by them.
No, no. Is it the
Without
fact? No, is it the fact that isn't it the fact that you were supposed to he would return when you vacate? Then you have not vacated. How will you be entitled to
No, no.
interest?
Lordship, when I will vacate your lordship, let them pay at least some sort of interest, your lordship,
No.
because they have for last 30 years, your lordship, they have enjoyed the amount.
No, no, you do one thing. You take
No.
2,50,000 additional from him. You pay another 2,50,000 because the
Not
5 lakh is the,
impossible, your lordship.
this
we
is
can't
by
pay your
dismissal with the cost
because
of 5
he
lakhs.
is in he is in flagrant position, your lordship. The hotel does not run. Actually, it is line. I will vacate your lordship, no problem. I will vacate your lordship, no problem. But so far the cost is concerned, your lordship, it is impossible on my part. As on today, your lordship, I am running some petty business, your lordship, where I can
Petty business. Where you have to pay 18,000 is a petty business.
no, lordship,
It's petty business. You are paying into the rent of 18,000 is
not
a petty
here, your
business.
lordship, not here, your lordship, somewhere else. Petty business somewhere else, your lordship. Garage I am running, your lordship.
Where?
Somewhere in Azra side, your lordship.
So you are having a business of, and then why do you require this?
That's why I will vacate it, your lordship.
Then-
I will vacate it, your lordship.
So you don't require even 6
but-
months.
If that amount I get, your lordship,
Well, you can go ahead with the execution right forfeit. He doesn't require the land also. You don't require. You have another business. What are you doing with this business?
lordship, I will vacate it, your lordship. Only thing, the security amount may be returned, your lordship, with some interest.
No interest. Interest too doesn't arrive. The question doesn't arrive. You every month you pay that 18,000. Then on the date on vacation, when you give the key,
I have already invested 5 lakhs, your lordship, in 2003. 2003.
and with a permission taken of a person who died.
No, this gentleman plaintiff, your lordship.
The
How
person,
he has
you
actually
say that
said-
you have taken the permission of a person who died in 1998 and constructed in
No, no.
2003.
Not from his father, your lordship, from the present plaintiff. Because innovation was made, your lordship, in the year 2003, March
Hello.
to 2003, September.
Let me dictate to hear, if you like or not. Heard Mr. S. Ali, the learned counsel appearing on behalf of the petitioner, Mr. Z. Mukit appears on behalf of the respondents. He's how many defendant petitioner? One. He is appearing for the petitioner. S. Ali appearing on behalf of the petitioner, and Mr. Jed Mukit appears on behalf of the respondent numbers 1A to 1H. The present, the present petition, the present application is filed by invoking the revisional jurisdiction of this court under section 115 of the Code of Civil Procedure 1908, challenging the judgment and decree passed by the learned additional district judge number 2 Kamrup Metro at Guwahati, hereinafter referred to as the learned first appellate court, dated 9/7/2024, in title appeal number 37/2022, whereby the appeal so filed was dismissed, thereby affirming the judgment and decree dated 18/3/2014, passed by the learned civil judge number 2 Kamrup Metro at Guwahati, hereinafter referred to as the learned trial court, in title suit number 173/2003. Before embarking upon, for the purpose of deciding as to whether this court or should exercise its revisional jurisdiction against the impugned judgment and decree. This court finds it relevant to take note of the এটা এটা কাম কৰা paragraph 4 and 5 যে কালি দেখা পাইছিল না judgment দেখাইছিল Hindustan Petroleum এইকেইটা ভৰাই দিওঁ। In the backdrop of the above proposition of law settled by the Supreme Court, the question arises as to whether this court should exercise its revisional jurisdiction. For that purpose, this court would finds it relevant to take note of the facts which led to the filing of the instant application. For the purpose of convenience, this court would refer to the parties in the same status as they stood before the learned trial court. There is a plain people write so long. A three-storied RCC building, popularly known as S.N. Sharma Building, at Ohio Market near Urvashi Shinmahan Fancy Bazaar, Guwahati, is the two premises as described in the schedule to the plaintiff. The suit premises originally belonged to one Satyanarayan Sharma. Upon the death of the said Satyanarayan Sharma, upon the demise of the said Satyanarayan Sharma, the suit property was inherited by the plaintiff, comma, his mother and his three brothers. The plaintiff was carrying on the hotel business in the said suit premises in the name and style of Hotel Manjusri. The said hotel business, however, did not fare well. The defendant, on coming to learn about the closing down of the hotel business, pay around 10 lakhs now. We are willing to pay. On the basis thereof, a tenancy agreement was entered into on 29/11/1995 by and between the plaintiff and the defendant, which would be effective from 1/1/1996. At the time of entering into the said agreement, the plaintiff was paid an amount of rupees 1,50,000, amount of rupees 3 lakhs, na? Had paid an amount of rupees 2,50,000 by two separate checks dated 27/11/1995. Another post-dated check was issued on 7/7/1996 of an amount of rupees 50,000, which was, however, not encashed. The said tenancy agreement was for a period of 3 years. And accordingly, the said agreement was to expire on 31st of December 1998, isn't it? It is the case of the plaintiff that for the months of November and December 1998, the rents at the rate of rupees 18,000 per month was not paid by the defendant. It is the further case of the plaintiff that as per that the plaintiff defendant ought to have come for renewal of the said agreement. But but the defendant did not did not renew the agreement. In terms with clause 4 of the agreement dated 9/11/1995, the rent was required to be increased by 10% after 3 years. After 3 years. And accordingly, with effect from 1st of January 1999, the rent ought to have been 19,800. However, the plaintiff defendant continued to make payment of the rent at 18,000. Nah? November and the year he did not pay. December he did not pay. Then thereafter he did not pay a single penny. From when? But you did not pay to you. It is the case of the plaintiff that in terms with the agreement dated 29/11/1995, the rent with effect from 1/1/1999 till 31st of December 2001 would have been rupees 19,800. Thereupon, with effect from 1/1/2002 till when was the suit filed? 1/1/2002 onwards, the rent ought to have been rupees 21,780. However, the plaintiff did not make any payment of the said rent. And did not pay any payment of such rent. Which is, and And as on the date of filing of the suit, the plaintiff was entitled to an amount of rupees 4,47,560. In paragraph number 16 of the plaint, the plaintiff had further stated that he has a bona fide requirement of the scheduled premises for his own use and occupation, as well as the occupation of his grown-up children to start their own business. It was mentioned that the defendant was apprised of the same aspect and was requested to quit and vacate. But the defendant not only failed to pay the rent, but also did not vacate. It was also mentioned that the plaintiff was ready to return the interest-free security deposit of rupees 2,50,000 to the defendant on the very day of vacation of the suit premises in favor of the plaintiff. On the basis of the above, the plaintiff therefore sought for ejection of the defendant on the ground of being a defaulter in payment of rent, as well as on the ground of bona fide requirement of the scheduled premises. The plaintiff has also sought for realization of an amount of rupees 4,47,560 along with future rent with effect from 1/6/2003. And the details of the amount have been given in the plaint. In addition to that, the plaintiff have also sought for an interest at the rate of 18% per annum on the amount of area rent. The defendant, upon filing of the suit, which was registered and numbered as title suit number 171/2003, 173/2003, the defendant and receipt of the summons by the defendant, a written statement was filed by the defendant. In the same written statement, the defendant denied that it was that the defendant was a defaulter in payment of rent. It was the stand of the defendant that the different legal heirs of late Satyanarayan Sharma were collecting the month rent from the defendant, but without issuance of any receipt. It was stated that as soon as late Satyanarayan Sharma died, the terms and conditions of the agreement dated 29/11/1995 became automatically extinct. And as such, the question of paying of enhanced rent does not arise at all. It was also stated that the heirs of late Satyanarayan Sharma never approached the defendant for execution of any fresh agreement. In a said written statement, it was also stated that the plaintiff stated that the defendant discussed the defendant had a discussion with the plaintiff in the early part of the month of October 2002. The plaintiff had asked the defendant to stop his business for the time being, as the plaintiff would start renovation or repairing of the said building. On such verbal discussion with the plaintiff, the defendant was asked not to pay the monthly rent till the opening of the hotel. It was also stated that the defendant therefore closed his hotel business from the month of October 2002 and reopened on 3rd of October 2003. It is the further case of the defendant that the plaintiff did not go ahead with the renovation. And the defendant, therefore, carried out the entire renovation, repairing oblique renovation by himself with a condition that the defendant would pay rupees 5,000 per month from the month of opening of the hotel. It was also mentioned that in that process, the defendant had incurred an expense of rupees 5 lakhs. On the basis of the said pleadings, the learned trial court had framed 7 issues. The said issues are reproduced herein under page 52. Page 82. On behalf of the plaintiff, the plaintiff adduced himself as witness and exhibited various documents. On behalf of the defendant himself adduced himself as witness and exhibited certain documents. The learned trial court while deciding the issue number 4, came to a categorical finding on the basis of the evidence that the defendant defaulted in payment of his rent. For the months of November and December 1998, isn't it, Mr. November and December 1998? That is the finding. Huh? No, that is a defaulter. That is a finding of fact. In respect to the issue as to whether the plaintiff had bona fide requirement of the suit premises, the defendant, the learned trial court came to a categorical finding on the basis of the evidence on record that the defendant, the plaintiff, had a bona fide requirement of the suit premises. On the question as to how much amount the plaintiff would be entitled to, the learned trial court came to a finding the defendant is also entitled to refund of the security deposit amount of rupees 2,50,000 as well as the uncashed check of rupees 50,000 from the plaintiff. How is it possible? For that check. And the defendant and the plaintiff did not, the court did not give you any say amount on arrears. Why? on the question of area rent, the learned trial court held that the plaintiff would be entitled to the area rent from the month of June 2000 at the rate of rupees 18,000 per month, minus the payment of rent already received on payment of the appropriate court fees. The learned trial court therefore decreed the suit, holding inter alia that the plaintiff is entitled to get vacant possession of the suit premises from the defendant or any person claiming under him. The defendant was directed to deliver vacant possession of the suit premises within 2 months. The plaintiff was also, it was also decreed that the plaintiff would be entitled to area rent with effect from the month of June 2000 at the rate of rupees 18,000 per month, minus the payment of rent already received on payment of the appropriate court fee. It was also held that the defendant is also entitled to refund of the security deposit of the amount of rupees 2,50,000 as well as the unencashed check of rupees 50,000 from the plaintiff. So, being agreed, the defendant preferred an appeal before the learned trial court, first appellate court, which was registered and numbered as title appeal number 37/2022. The learned first appellate court by giving a detailed, by taking note of the evidence on record, affirmed the judgment of the learned trial court and dismissed the appeal. It is under such circumstances the present appeal, a revision application, is before this court. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the perusal of the materials on record, it is seen that both the learned trial court as well as the first appellate court, after examining the evidence of the witnesses and taking into account the documents adduced, exhibited, had come to a categorical finding that the plaintiff herein was a defaulter in payment of rent. The findings of facts so arrived at in respect to issue number 3, issue number 4, being based upon evidence, do not call for any interference in exercise of the revisional jurisdiction of this court. This court have also taken note of the decision of the learned trial court in respect to issue number 5 as to whether the plaintiff had bona fide requirement of the suit premises. And it is seen from the evidence on record as well as the discussions so made by the learned trial court as well as the learned first appellate court that both the courts below were justified in arriving at the finding that the plaintiff had bona fide requirement of the suit premises. Consequently, This court does not find the instant application to be a fit case for exercise of revisional jurisdiction under Article Section 115 of the Code. Mr. S. Ali, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner is presently carrying on business in the said premises, and it would be difficult on the part of the petitioner to, if the decree is enforced immediately. Some time, therefore, may be granted in that regard. Mr. J. Bukit, the learned counsel appearing on behalf of the plaintiff, submitted on behalf of the defendant, defendant oblique petitioner. J. Bukit, the learned counsel appearing on behalf of the legal heirs of the original plaintiff, submitted that the plaintiff have been occupying the said suit premises despite being a defaulter in payment of rent, as well as the bona fide requirement of the plaintiff. The plaintiffs have been caused, severe injustice has been caused to the plaintiff on account of the delay in disposal of the eviction proceedings. He submitted, therefore, that no time should be granted to the plaintiff, to the defendant. তাৰপিছত সেইখিনি মই সেইটোতে গ্ৰাউণ্ড submission ইয়াৰ খালি এইটো আগতো 18,000 কৰি দিব. Within 10 days, he has to submit undertaking. But how do I enforce it? The trial court has given that, no? Problem arises, the trial court was wrong. You should have filed a cross appeal. I can't increase that. 18,000 দিব আর এইটো নহলে per month for 6 months as in the form of a compensation, not a I have a particular year. I started it with Mr. Samnur Ali as the counsel who was appearing for the defendant. What is that matter? Yes, Mr. Ali, what was that matter? Huh?
On what point, Your Lordship?
And this landlord tenant. 10 days you submit the undertaking before the trial court. Otherwise, yeah, LCR return. We could put a cost of 10,000 upon you. Then it's dismissed with a cost of 15,000. And you can recover all the rent by moving in the executing court. And it will be adjusted against this. And your payment of this 2,50,000 which is there would be you don't need to pay. That would be set off against your claim.
I think time has been given, Lord.
Huh?
Time has been given.
6 months. I'll give you. Today is what? I think it 8. 25. We'll take it from first. First 1, 2, 3, 4, 5. By 30th of August 2028, you have to vacate. 30th of August. No, 30th no. No. Will be March. 30th of September 2025, you have to vacate. And the undertaking.
So, Your Lordship, supposing undertaking is not given there.
Oh, immediately they can go ahead.
You have to
Immediately. You can get that I'll say. If they don't give it within 10 days from today, you can go ahead with the execution. And in the execution, I will say that you will be entitled to the rent from the date on which the filing of the suit has been done till the date of today. And these things, these claims, you can have very well make it out there before the executing court. The executing court shall give an opportunity to them. The payment of the amount of rupees 2,50,000 would be a set off against your claim for disinterest. And cost is 15,000. Do you have any intention of not giving the undertaking?
No, I will have to ask them.
client.
No, then we put it at 1 lakh.
Available on
You
also
tell
it's
me,
not-
I'll sign it tomorrow. We give you a, yeah,
that is the
tomorrow.
problem. It is
I'll
not
then I'll
available.
put it at 1 lakh cost.
Contracted.
I'll put it at, yes, Mr. Sayawala. You're going to vacate when?
Back, Malad, few minutes back, Malad, my junior received call, Malad, that 1 year, but without Malad return inspector, Malad, it's difficult to something.
1 year is too much.
And that too, Malad, without return instruction, Malad.
No, you have to file an affidavit by the managing director. You have to file an affidavit by the managing director. Then we'll catch hold of this managing director if he doesn't pay. Isn't it? And for this 1 year, you have to pay him some rent. Oh, 5 lakh he has to pay. 5 lakhs also. You have not deposited the 5 lakhs till now. Pay that 5 lakhs. We do one thing. Let me come back. I'm coming. Is this partnered? That I've paid. The GM Sahavla, the Learning Senior Counsel, appearing on behalf of the ASTC, he submits that the said that the instructing counsel, Ms. S2D, been informed that the ASTC authority would require 1 year time for vacating the land in question. Taking into account its submission, this court posts this matter on 22nd of April 2025. At 2 p.m. The managing director of the ASTC shall file an affidavit in respect to such undertaking. Apart from that, in the said undertaking, said affidavit, managing director has also undertaken payment of rupees 5 lakhs. 5 lakhs. As have been passed by the learned court below. Matter be shown as part of.
Fifty-five.
The coupon may take some time, but you will get it. Huh? Yeah, you will get it. But I know you'll get it. You'll get it and also you'll get everything. You wait for something. I'm not here from first to 11. I'm not there, it will be of no consequence. The affidavit we filed on or before 11th of April 2000. Yes, withdraw.
Tenancy, my lord,
I dismiss it.
dispose of directing.
No, no, dismiss it. This is a fundamental mistake which you have done now here.
No, see, one thing is.
No, the question does not arise for the fact that this acquisition is done under the Assam Land Acquisition and Requisition Act.
64.
So therefore, when you are seeking a reference under 12, you are seeking actually a reference on the 12.
Yes,
When you are seeking a reference on the 12, the Land Acquisition Act 1894 kicks in.
yes,
Land Acquisition Act 1894 makes a reference to a civil court.
yes, madam.
The civil court will be the principal civil court, which will be the district judge of the concerned district.
My lord.
So therefore, the jurisdiction is there.
Yes.
Unlike if it is done under 64, it will be different.
Right.
But 64 does not. He may file any application out there,
Right.
but the acquisition having been done, it will be before that court. That is the court of the civil court. It has also been defined out there in the 64 Act. So therefore, he has the jurisdiction.
By this or that side. But actually, let's see what happened. Initially, the equation which was created at that point of what I have dealt with the matter, but that in the diameter was there in 2013. That's why I have go to the 51 section where notification is required. Then we saw the notification found that court has no jurisdiction at that point of time, while that cognizance was taken. Because this notification affected,
This is only will come if it is an acquisition under the new act.
my lord, that is the problem. My lord, all now this problem are coming.
No, it is not so because of the fact this is clear from this document
This is
itself.
clear, no, this is clear, my lord, but my lord, what happened?
Kindly see the acquisition. The acquisition LA notification
The
is
DC
under
office, my lord, the DC
661.
office is creating a big problem for everybody. Lordship see that the procedure which they have followed. There is no any problem of that step they are taking care of that. Agent to date 2013 actually, Lordship can you see here they have the equation was proceeded under 64. But the compensation which has been determined clearly mentioned that 2013 in the light of that.
Yes, therefore it has to give. Because what they do, they go by the 64 Act.
Right.
In view of a government of India notification,
Right.
government of Assam notification, they pay the compensation under the
13.
13 Act. Now, do you want to go by the 13 Act? We nullify the acquisition. So tell me, you tell me.
No, no.
Because
no.
what the government of Assam is doing is for the help of you. Because otherwise, they have to go for the social impact assessment.
Yes, sir.
These are all being foregone by going into
Yes.
this section 6.1.
Because that is the basic object of my lord,
Yes.
formation
So
of.
this is being foregone by taking into account the Assam Land Acquisition and Acquisition Act. And this is being done. So if you want to do it, okay, if you say that, kindly nullify the prayer, I will
But-
say that.
No, my lord.
Tell me,
13, my lord, that exists, my lord. There is no any problem.
okay, how much cost?
Please, my lord.
Cost is per case? How many cases are
My
there?
lord, 10 cases.
Let 10
But
cases,
Lordship kindly see the- my lord,
15,000
publicity,
each,
my lord, that,
1,50,000.
my lord, Lordship,
Let it go to the
government is
Guwahati
there, my lord.
High Court Bar
Government is already
Association.
some, my lord, that because companies is enhanced, my lord,
No,
because
pay
project
it to, the enhancement will happen only, don't
But-
worey, they
but-
always give a very low
my lord,
figure,
Lordship,
say,
no,
don't
it-
worry.
my lord, that we have to fix the
Enhancement
amount
will
in a
happen.
particular project, my lord,
But project, so what? How does
Certainly.
it matter? So first of all, you have to understand, this acquisition which is being now resorted to be done under the Assam Land Requisition and Acquisition Act does not provide any avenue. One day, someday, if it is being challenged properly, this act is required to be struck off in view of the recent act.
my lord, that only thing that at that point of time, while we challenge that retrospective effect, that noting was given by the learned, my lord, reference. That's why, my lord, retrospective was not the part of that notification. Therefore,
That is not, that did not come into
that's
the
why, my lord, we
picture.
have good ground to challenge that point of time, my lord, because that retrospective was the totally perversity.
Okay, 10,000 per
My lord,
case.
my lord, because government, my lord, this is, my lord, AIDC is not government, my lord, that they are undertaking, they are working, my lord, on the certain project for the welfare of the industrialist, my lord.
But you have the avenue to file 10 cases, so obviously,
My lord, lordship thing is that ultimately, lordship may kindly remand that matter, will, my lord.
No remand, dismiss.
My lord.
Dismiss. দেখো ঠিক এই এখন 64 এখন আসাম ল্যান্ড একুইটি
No, lordship one judgment, lordship pronounced, which is very good, out of which lordship clarify the position of 64 and that 2013.
which one
2023 judgment, my lord.
so many judgments like that
Yes, lordship has passed lots of judgment. Once I click, my lord, I have got.
কথা নহয়
My lord, may I please?
let me go like the CPC, now all the three acts, Land Acquisition Act, Assam Right to Fair Compensation Act, 64 Act, I now remember, I now remember by heart all the provisions. And in fact, what has happened in your case, the challenge out here against the revenue, against the court's jurisdiction could not have been done under 227. You should have challenged the reference order.
Hello?
You should have challenged the reference order, not the reference proceedings.
Basically, my lord, that 74 lords, I think, was indicating about that, against the 64. But thing is that, my lord, 64, my lord, we are apprehending because, my lord, that if suppose amount will come, my lord, we will be in a danger line, my lord.
Huh?
Because, my lord, what happened, that we have received the amount for that particular project, that is over. Now, it very become difficult to suppose, my lord, if suppose any enhancement come to adjust that amount, my lord, because project is on the way, my lord, that otherwise affect the project.
Yeah, it says the court means the principal civil court of original jurisdiction and includes the court of additional so and so, so and so. It is given here to be. Then, so this is the reference on the 12th.
Yes,
Then it will go here only. The land is situated there. And in this delay, who is going to pay the interest? Because if there is an increase in the amount under 28, there will be increase because the 28 will kick in. And because of that, the interest will go up. Now, once the interest goes up, how do you take care of that? Then, or the parameter provision
Yes,
here will be 71.
interest will be counted.
How do you, then how do you take care of it? এই contribution 93, 2000 নালে এখানে contribution. Okay, today a lot of serious matters are finished. All liquidation.
One stage already morning time.
Huh?
Item 1 to 30.
Thank you. এই item को पायो ना 55 पूरा 64 हाँ Heard is the summary of the limit council hearing on behalf of the petitioner. The present batch of applications are filed challenging the jurisdiction of the district judge, Amingam, Kamrup, to decide the reference cases on the ground that when the reference was made by the collector to the court, the district and session judge, Kamrup Amingao, did not have the jurisdiction. As the notification dated 38/2018 only conferred the jurisdiction upon the district and session judge, Kamrup Metro. It is also the case of the petitioner herein, that it was only on 27th of May 2020 it is only on 27/6/2024. The jurisdiction was conferred upon the district and session judges of all districts to act as the land acquisition, rehabilitation and resettlement authority. It is therefore the case of the petitioner that the reference proceedings which are now pending would not have been registered before in the court, registered in the establishment of the district and session judge, Kamrup Amingao, prior to 27/6/2024. Although now the said reference proceedings, although the district and session judge, Kamrup Amingao, now pursuant to the notification dated 27/6/2024 has the jurisdiction. That's your case. In the opinion of this court, the entire case of the petitioner is misconceived. Primarily on the ground that the acquisition is not done under the provisions of, the acquisition of the land was not done under the provisions of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. But the acquisition was done under the provisions of the Assam Land Requisition and Acquisition Act 1964. In terms with section 2B to Act of 1964. In terms with section 2B of the Act of 1964, the term court have been defined as the principal civil judge of original jurisdiction. This court further finds it relevant to take note of section 12 of the Act of 1964, which stipulates that the collector shall in every case where any person is aggrieved by an award made under subsection 3 of section 11, make an application requiring the matter to be referred to the court. Therefore, as the acquisition was done under the Act of 1964, the district and session judge, Kamrup Amingam, had the jurisdiction, and the reference which was being made by the collector to the district and session judge was in accordance with the Act of 1964. Consequently, this court finds no ground to exercise its supervisory jurisdiction in the present proceedings, present batch of petitions, batch of applications. Accordingly, the petition stands dismissed. All these batch of petitions stands dismissed. The interim order passed in all the proceedings all the proceedings passed by this court. Same date. Interim order.
Interim order, location not extended.
No, it's same date, na?
Yes.
On Sailubadi.
Yes,
in
we'll
the-
let them
on-
communicate.
by this court, whereby the reference proceedings have been stayed, are vacated, and the party herein and the petitioner herein is directed to appear before the learned reference court, that is the court of the additional district judge, Kamrup Aminga, on 28th of April 2025 for the further continuation of all the reference proceedings. The registry is further directed to apprise this learned trial court, learned reference court, about the instant order. The details of the reference cases which were the subject matter of the present proceedings are given in the appendix herein below.
Thank you.
No cost?
49 item number 40. 49 item, and two times it has been listed for it's small issue, lordship, can it be Thursday, madam?
No
Limitation.
Thursday business. You see, I am today functioning at my level best.
Yes, no doubt, madam.
Now, why I'm saying it, see, won't be there on
Madam,
27. What is that item?
49, madam.
49 is what?
RS. One point of limitation.
Oh, where is it? Item number 49.
Two times, my lord, it has been. But the city of Glen, madam.
49, RSA 2018. Where's the other side?
Other side, there is, my lord, no appearance from other side, my lord.
What is the issue?
Issue, my lord, that limitation trial court decided in my favor, my lord. The appellate court said that no limitation that has been abandoned, my lord.
Huh?
Limitation point has been abandoned, that's the lordship has framed the substantial question of no limitation.
I feel.
Yes.
Other side did not appear.
Only
Let
single,
me finish up the other matters. Let's see.
Madam.
Can we see? Take it today. We have another 1 hour, 10 minutes. Let's see the other matters.
madam, definitely.
What is this RSA?
39.
He was. Yes. What is it? Yes. So you do me have a case. It was some necessary party. Record that come.
Titles of record has not been received.
Record has not been received.
Not received.
Huh?
Not received. Titles of record not received.
So you want to escape today? You want to get away from this court today? Okay, at the request of the council for the pure day.
But
Do you have any objection if he wants an adjournment? At the request of the learned counsel appearing on behalf of the appellant, matter stands adjourned to be listed again on when? When do you want the death knell? No, on third of June 2025 for hearing. And full stop. The registry shall ensure that the records of the learned trial court are placed before this court in the next day.
Silent.
44 and 45.
Oh, this matter. It's a difficult case. Good case for you, I made it out. Isn't that the case where I made it out?
Yes, sir.
What was the case?
The substantial question of law was framed by your lordship. Whether the suit is maintainable without state of
Oh, yes, state of Assam.
authority granting ownership to the defendant by the order dated so and so, then
Yes, yes, I
Yes, yes,
remember
I
this
remember.
case. Yes, Mr. Dekar. You find out anything? Very difficult. I thought. Can it be in any manner? If I remand it also, I can't remand it. Very difficult. So what to do? Because you may have a good right. How to take care of? Very difficult. You thought about something. You have a good case. But because of that, without the state of Assam being made a party, it- I can't remand it also. Because this is fatal. And if I allow this petition on this point, your right over the land goes. It's a very worry. How do you take care? Could that be a formal defect? Could it come within the sufficient cause to withdraw the suit now? That is what one of the thing I was thinking. Can you? No, maybe not on a formal defect. You see, on other grounds. See, those judgments are that non-joinder is not a formal defect. But what about the grounds? You see order 23 will 1, 3 or other. Can that be the only way? That is the only way I find. So can you think about that position?
Before,
Mm.
uh, one aspect. Right. For a dictionary that can not. Now, this was the basic foundation of the case that they are not my, they are not my tenant. Ultimately, everything goes. Now, so far as this aspect of the matter is concerned, segregated for. Right. Now, that issue can rise in from the report as has been by the previous judgment. And that is the issue. Now, those findings are in my favor as court has held that he is not. Now, if he's not a tenant, then if the dual relationship of landlord and tenant doesn't exist, then very acts it is to operate.
But how do I pass that order? You see, your main prayer, he gets his title on the basis of that document.
So, if this part remains, that is not a tenant.
The act ceases to apply. And if the act ceases to apply, the entire proceeding under 23 is without.
But under proceedings, under 23 is without jurisdiction. But who has exercised the jurisdiction again? You see the problem again, I thought about it. How do you take care of that position? Who has exercised the jurisdiction? And thereby conferred a title on him. That is the problem. And that too in a case where you have withdrawn.
And for a monthly committee also, if lordship, for which this monthly committee was that is a monthly committee judgment.
I don't have any. There's some judgments made. Please, for Bihariland, yes. Tell me.
Third also, trial, adjudication, particularly the cancellation of the patta. So the appellant granted the patta initially, that was cancelled, and that was allotted to the respondent. Now, appellant filed the suit saying that my cancellation of the patta is bad, and his allotment is bad, though no declaration was followed. Now, trial court ventured into that question, and eventually held that one of the para 2 last quarter.
Hmm.
So that single judge. Para then the finding of trial court. After granted the number of the appellant is valid law, then the finding grant of patta in favor of the respondent was valid. Letter statement is the only question argued by the learned counsel appearing for the respondent before the revision time was non-existence of patta in compliance with Article 290. Holding the contention satisfies the judgmental duties of the trial court and that of the person before the district. None to satisfy petition. Now, paragraph 4 again. Now, after into Karnataka, the appellant filed a writ petition in the High Court. He sought the cancellation of the patta granted in favor of the appellant. High Court filed dismissing the petition and given liberty to other appellant to avail the regulation of filing a suit for challenging the cancellation of the patta pursuant thereto notices under section 80 was given. But the appellant did not increase the monthly committee or the government as a court. Therefore, the suit is
No. This was only a suit for possession. This is a section 6 proceeding. That is why they did not make those people a party.
now.
Now kindly come to paragraph 6. What is the plea? And how does it differ from your case? It is seen that appellants were admittedly allotted their aforesaid area so and so. It is true that in the plain no specific prayer was made seeking declaration of the invalidity of the cancellation of the patta granted to the appellant or invalidity of the patta granted in favor of so and so. Then you kindly come to paragraph 9. Paragraph 9, kindly see the learned also.
Gone into all
But here there is a title being given by the government. Okay. I think on this basis, let it go to Supreme Court. No.
they have Yes, overcome order 1 rule 13.
Not necessary. Order 1 Rule 13 will come only in a case where there is a necessary, some other parties are there. But if they don't raise it also, can you take care of Order 1 Rule 9? How do you take care of that?
I have a few more points for,
Hmm.
for a moment, if the lordship has para 24.
Yeah. Hmm.
That in para 24, the president has taken a single side was bad for the government, but current process not show that it was then in the state of Assam was not arrayed as a defending. Therefore, while defending the issue of the government trial court had held that there was no statement that part from the NCR of 1906, the learning council for the objection of cross filed by the learning court regarding non-maintained authority transport. Two, according to the London First Appellate Court, and also given a finding on number 2 as framed by the learned transport, thereby concurring with the findings of the learned transport. Therefore, in the considered opinion of this court, when the non-joinder of the state of Assam and one of the not present, the appellant and that there was no objection and or cross objection on the decision on the transport on issue number 2. Issue number 2 of non-joinder of the party is the second part. This regard, the court is reminded of the case of Nidendra Mohan Lahiri versus Rajendra Nath. Wherein this court is held as follows. We have observed that the court should extend the presentation in absence of specific government in the registration as to how and in what circumstances the change is not maintainable in law. A mere vague recital in the resident statement without anything cannot be the basis for raising such an issue. It is a basis for a right decision and object on the real substantial point of difference. The party emerging out of vague.
No. This was Mr. Counsel. This is the absolutely. I'm not this type of. See that I know. I don't require those type of judgments for that. The law is very clear on that. That you have to normally do it. But here you see the case. They are challenging a particular, asking for right title in interest and for cancellation of a deed of sale. Why they took the plea of the state of Assam being made a party? Because they are saying about some mutation entries. So doesn't go to the root of the matter, the mutation entries. But here is the case where without challenging that, without a decision on the particular thing as regards the patta, you cannot go ahead.
I disclaimer. Suppose for a moment, beside prayer, see, if the
No, without prayer C being there, you have no right.
now, my lord, if the other issues are in my favor, then it's a
No, that has attained finality. Otherwise, that is the court which have the act has given specific powers under the Act of 1971 to deal with that aspect. And the court had done it. The matter went to the appellate authority has done it, and then the matter you filed the writ petition you have withdrawn. And now if you keep on raising, this is an absolute abuse. Can we pass an appeal? In appeal, can we now think about? In appeal, can we impose cost upon the plaintiff? Unnecessarily spoiling the time of the defendant.
My lord, one
Answer that first. No, answer that first. Can we impose huge cost upon you? Unnecessarily spoiling judicial time. 50% should go to the judicial infrastructure and 50% to the appeal.
now, my lord,
No, nothing else. Now the question is how much is the cost?
one last subject.
You submit on, that is a more substantial question of law. Submit on that.
Points I think so first of all, how court has said, ultimately what we
How many years the suit has gone?
And it was filed in 2008.
2008. From 2008 till 2025.
They did not or did
No, 17 years, 17 years you have spoiled the judicial time of the court. So I think 25 lakhs you pay to the judicial infrastructure on that. No, 25 lakhs. I don't have any case in that.
First of all, you're not, partial distinction, it is not a regulatory act. It's a quasi judicial act. So even if we make, the, change the party, the Supreme Court, of course, in a different context has said that when it comes to adjudicatory orders, the adjudicating authority need not necessarily be a party. This is because ultimately the adjudicating authority has already passed the judgment, it will not come forward to defend this order. Which is why, at times, if it is that if it is quasi-judicial decision or adjudicatory, his presence as a respondent may not be necessary. And secondly, my lord, since we are on the point
Mr.
of
Deka, you know that submission which you are making holds no water at all. You are just making the submission and spoiling the time. You're spoiling the time of Mr. Samaria, who is waiting to take up a matter. Some of his matter. There are a lot of other councils who have better matters.
the appeal is not pending.
Huh?
Appeal is not pending.
How?
The lordship comes to very important.
Why?
Third parties are not. Parties are not.
Here.
In this appeal.
Who are the parties?
The defendant number 6, because there has been a transposition. Some owners were erased pro forma during the, pendency of the suit, pro formas became plaintiff. Out of them, one is not even a party. And it's too late in the state to exercise of the conflict.
Where is that?
Page 45.
Did you raise this issue earlier before the court?
It was, during admission, it was 1/3. The 1/3, if I remember correctly, I did not. This was point.
So that is the ground we give. You file an application. You see, order 41/20, although has a provider, who can give it? Court still have the power. This is the thinking.
But an application has to come.
We'll file an application. I am not going to file an application if required. Because you should have raised that issue then and there. Somebody appeared out there. Why didn't you raise that? It should have been done on this. At the time when the matter was reasoned, on 14/3/2014, before the substantial question of law was framed, the respondents were duly represented by Mr. B.N. Sharma.
Six. Not even.
No, no, no. Respondents have duly appeared. Are you not appearing for those respondents? How can you raise that issue now?
They have raised it in state of security during the course.
No, I raised it. They didn't say anything.
So even this is something, one party, if one can done.
Okay, we make them a party, don't worry. Who is the person you know? Whom have you not made party?
Number 6 has page 45.
You were the plaintiff?
I was.
Huh?
I did. And certain performers became certain the transposition.
Where? There is a plaintiff.
Exactly 44.
You are not appearing for them?
I'm appearing for 780.
No, are you appearing for those performers who were transposed? When did you appear? When did you appear?
I'm appearing for 7 and 8.
Yogendranath Sharma and Bolindranath Sharma.
Fix is not Mr.
Who is not a party?
Fix.
Dipali Sharma.
Readiness.
Are you paying for her? Him. Then who are you? What is his name? Now let us give the judgment. Let it go to. It's fixing it. Only favor I can do to you is right away short, crisp judgment. Quickly. For that, Supreme Court may help you out. And remand the matter. That is the only favor I can. Like Mr. Samari is helping. But not quickly. Please.
State has not. Has not been done. I guess.
He doesn't know what you have done. The state will be shocked. The High Court had, the trial court and everybody has passed an order by which we don't know anything. You are, at the court comes to a finding. Just tell me, the court comes to a finding. How could the court come to a finding that he did not do that or did it without asking him a question? That is the basis on which you have done it. You are saying that the entire procedure. No, what you are challenging is the procedure of granting a khatiyan to him is wrong. The procedure. I would have understood. The khatiyan, he has done some mistake is a different thing. That's not the question. The question is the trial court and the first appellate court hold the procedure of granting him here and the procedure who does it, he is not there. Thank goodness.
More mentioned that question whether this act was applicable at all. Because issue number,
Whether it is applicable or not is a different thing.
now for that.
Whether it is no, first of all, the without those findings that his authority did not apply its mind in that manner. Without those findings, can you have a judgment in your favor?
That is
No, it cannot be.
because
I think better the Supreme Court answers it properly now. Yes. Now, 25 lakhs is the cost to be imposed upon you for spoiling the judicial time.
para 26.
No, 25 lakhs.
Find that if the appellant had specifically pleaded about the non-joinder of the state of Assam of the state, and if still the said party was left out, then the dismissal on the ground of non-joinder would have been justified. But in the present case, there is concurrent finding by both the courts below that the suit was not bad for non-joinder of necessary party. Thus, non-filing of the objection or cross-objection by the appellant against the findings of the learned trial court amounted to waiver of the. As such, the court has no hesitation to hold that the issue of non-joinder of government of Assam is a new taken at the second appellate. But all said and done, whether it's deciding right interest between the plaintiff and the defendant. Now, whatever declarations are passed, your lordship is aware, will only be binding between the parties as per section 36 of the specific opinion. Now, it is for the state to perhaps to urge in a different proceeding that this judgment is not binding upon it. So long as, my lord, they do not raise it, I did not get the.
You see, without C, you cannot get A.
Coming to that, my lord.
Without C, you cannot get A.
Ignore it. Because it is.
So so you say that you give up C? No. You say that you give up C. Make a submission. Then I'll pass it order again. Without C, it cannot be done. So therefore, the trial court was wrong. You say that. No, Mr. Deka. No, let us now come to the point. Give up C. You give up C. You want to give up C? No, you cannot. You have to tell me. If you want, no, you are making a submission. If you want to give up C, I'll record it. I'll frame another substantial question of law that without C, can the learned trial court had given A and B?
That
You abandon C. Because without C, you cannot get A and B. That is also my friend. Because he has a title which is being conferred by an act. So without C, you cannot go by A and B. Oh, yes.
But he also comes with the value.
No, because nullity will be when the person is there. Without that person, without the authority being there who has passed the order and the government granting them the patta, on the basis of that, you cannot do so. You will have what you are submitting after this question of law by which a Pandora's box have been opened by me. If I answer it that it is not required, it will have far-reaching consequences in all cases. Tomorrow, just for example, let us think. You have a particular Delhi. Your land, you are the owner of the land, he is being given out there. He has got a khatiyan. Tomorrow, you both of you enter into an understanding. Say, look here, I'll pay you this much, you give up your land. You pay him some amount. Why should we involve the government who has given it? And the government grants him up here along with certain conditions. Okay, why should we give him out there? Let us both file a suit. File a suit, consent, decree, finish. No. This can happen without the state being a party. It will have far-reaching consequences. Take up the case of Assam Land Fixation Act. A person who is in occupation of the land under 16 will be given the possession, the right of patta out there. And tomorrow, once this patta is being given, there are conditions given that for next 10 years you cannot sell it. Okay, what do you do? Okay, we do one thing. Whatever, maybe we want this land out there. We'll go for a challenge to that. Let the DC or anybody don't know about it, we'll get a decree. Finish. Done. These are the far-reaching consequences. These are statutory orders. And the statutory orders, you have challenged it before the appropriate forum. The appropriate forum did not interfere. You filed a writ petition, then you withdrew. Then at best, do you have any cause of action out here? And later on come up and get a decree against the person and say that this person did not act in a particular manner in which he ought to have followed the act. Without that person, you are party. This is the finding of fact. How is it possible? Now the cost is how much? 30? 30. 30. 30. 30 lakhs. You pay for the judicial infrastructure of which court it is. Borpeta. Borpeta will have they will have some good place. Something good will be done. Maybe. Don't you think so?
What exactly is your lordship is that state is not for deciding age?
But without C, A and B. Now, therefore, I'm asking you, I'll frame a question number. You give up C. The moment you give up C, I'll frame a question number. You give up C. No, Mr. Dekar, give up C. No, don't come up with these submissions. First, if you give up C, I frame a question of law. And take it up.
Automatically.
No, I'm saying let us give up C. You give up C, then we frame a question of law and have it again on 22nd. Give up that. Okay, you want to give up. Then don't come up with things. Okay, today I've imposed a cost of 10,000 upon you for spoiling the time of the parliament. Had thought for time today was to obtain instructions. So taking into account the matter has been heard at length on the earlier occasion, and this matter is of the year 2014. This court adjourns the matter to be taken up again on 22nd of April 2025, taking into account that the respondent have sought for time a cost of rupees 11,000 is imposed upon the council appearing upon the respondent, council now, upon the respondent, to be deposited before the court. Basically. On the report.
46.
Yes, what is this?
My lord, what happened, my lord? It's coming for against the first appellate order, my lord. Appellate court order. Whereas, my lord, here, my lord, the land belongs to the government, my lord. The dispute between the individuals.
Same problem, same problem.
Same problem. But here, my lord, the government was made the party at the suit, my lord.
Where is the government apart?
Government said, my lord, they have verified the land. The Mongol has reported. And my lord, what happened, my lord? The land is under my possession, my lord. I am the plaintiff. In this appeal, my lord, I'll bring first appellate court, my lord, the government was the party. That's why I have come to the first appellate.
Whether the first appellate court is correct in concluding that the annual patta land standing in the name of so-and-so was annulled going to gift made to so-and-so. That's the only substantial question of law.
But at the time of the taking this appeal, my lord, your lordship also came in substantial question of law, my lord. The law is that, my lord, that question is that whether the learned first appellate court is correct in concluding that the annual patta land standing in the name of Bihali Kosari was annulled owing to the gift made to the appellant by the said Bihali Kosari. That is ordered at the 4/1/2017. But what happened, my lord, actually the land was 5 acres of land was belongs to Bihali Kosari. She was on paid by the Mohammedan. In the year of 1964, my lord, 5 acres of land was gifted to the Habib Dunia, who were already died, my lord. He was the appellant.
No, what has happened in your case?
My case is that, my lord, the appellant on the,
You are the plaintiff.
and
What happened?
what happened, my lord, what happened? I have to appear before the trial court by claiming right title and interest. The trial court has allowed my application, my suit, and thereafter, my lord, they have come
Right title and interest in respect of what?
in respect of the land, which is belongs to me, my lord, like I have
Declaration that the plaintiff has right title and interest over the suit land by dint of adverse possession. Adverse possession. Isn't that your case?
first position, my lord.
That is your suit. Isn't that the suit? Then what are you saying? Mr. Bolwa, you are not ready. You are not ready. You are saying something else. You are asking for right title interest on the basis of adverse possession. Cancellation of the order passed by the circle officer in referring to it. Declaration the correction of the Sata Sumoto as illegal to be so and so. Ejectment of the defendant number 3 and so delivery of possession of the suit land and house to the plaintiff.
Yes.
What?
Actually, what happened, my lord?
No, when you are asking for ejectment of the AR from the suit land, where is the question of adverse possession? You are not there.
No, no,
Adverse possession is person who is in possession.
I mean, still I am in possession.
Then why you are asking for ejectment?
Ejectment, my lord, some part of land.
You are not saying from the suit land.
Yes, it's suit
There is
land.
no part of suit land.
Suit land, my lord.
There,
Check, my lord, physically,
there is only one land.
One
Suitor,
11 letters
schedule A.
only 11 lessons.
Then you are asking for that. How is your adverse possession permissible?
At third position, what happened, my lord? Actually, what happened, my lord? Our relation was tenant and owner, my lord.
If state intervenes over out of love and affection the 5 acres of land to the plaintiff who accepted and took possession of the gifted land in the year 1964. Plaintiff cleared jungle and started cultivating. that in the course of time, as population increase for a long year needs, he sold some of the lands to different person, that in course of time, the aforesaid land converted in India. Other, so, the time into financial condition most of the land and so on as its benefit of the want to apply anything of the land is institution before the state. What is the suit you have filed?
Yes. My lord, what happened, my lord? The fact is-
You have said that you have rented out the room to the defendant number 3. Okay, then why you are asking for right title on adverse possession?
What happened, my lord? Some person. This is interesting, my lord. What happened, my lord? In the meantime, he has shown an unregistered sale deed.
Who?
The defendant number 3. He showed the unregistered sale deed has been executed by the Habibullah and he, and therefore he has the right. This the land belongs to him, and therefore, my lord, some persons who was originally taken the 3 rooms, Kasa room,
And you want right title in interest over dark number 186 and 187, which belongs to the government.
and my lord, trial court has given me that. Can you see the order?
No, understood. Very well,
And
very
my
well.
lord, they have come to the appellate court. My ground is that. my
Mr. D. Borua, better don't do this type of matters before me. Yes. No, if you say that you have rented out the room to the defendant number 3, so why you are asking right title in interest on adverse possession against him?
For a long time, since 1964, my lord, I am in the possession of that particular land. By the only strength of that unregistered Casa sale deed, he is claiming that that land belongs to him. That's why I am coming to that. That, my lord, I am in the possession since long back, 1964, when this land was gifted by my grandmother. We are in there only basis of only strength of.
And who is in possession?
I am in possession.
Then why you are asking for ejectment?
No, my lord, because what happened at the first appellate court, page 72, the first appellate court says that the 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 defendant number 3 submit the unregistered sale deed only to prove his possession. Only to prove his possession. That means, on one hand, I have been get out from my land, and other hand, on the basis of the only strength of that unregistered sale deed, that is the wrong concept by taking by the appellate court, first appellate court, he has given the possession right over that 11 lesser of land. That cannot be done, my lord.
So,
That cannot be done.
so this will come under 49
Yeah, section 49.
for political purpose.
Political purpose of Supreme Court says only 2 purposes that can be used. One is for the specific performance, and another is the only monetary transaction.
No, political purposes.
Political purpose of transaction, my lord.
For political
no
purposes,
dispute.
to the effect that he has been granted, handed over possession. Yes, that is the law.
No, my lord, my submission is that if it is that unregistered sale deed can be used only to two purpose. Specific performance, this suit is not for specific performance. Secondly is that suit for the, secondly is that as evidence of any collateral transaction, which by itself is not required to be affected by the registered instrument, a collateral transaction is not a transaction affecting the immovable property. But the transaction which is incidentally connected with that transaction. Transaction, my lord. There is no dispute regarding the transaction. Dispute is that who is in possession. I am in possession.
No, the moment you are asking for ejectment of defend number 3, you are by yourself admitting that he is in possession.
He, by forcefully, he has gathered some article to construct a permanent structure. That's why my lord ejectment is come.
And the question of law which has been framed has no meaning. How is that annual patta is concerned? Nobody has a patta.
Somebody has.
Then why this question of law is framed?
That question of law has been paid that on the basis of that, at that time, my lord, that land was annual patta.
And you have sold many of the government land.
Earlier, that's it, okay, earlier, and they have already, my lord, mutated that land to their name, my lord.
No. So, Baba, no. At the request of the learned counsel for the appellant, the matter stands adjourned to be listed on 29th of April.
Obliged, my lord. Obliged.
Yes, Mr. Samaria, your case. Let us see your case, what is there. Yes, others may go if they don't have anything else. Anybody having an urgent matter?
Another page 41, issue number
Vote
2.
in favor without setting aside the finding of the line. So find the issue of the. Oh, this one. That's the case of remand.
Yes, sir, that is a fit case. Lordship could remember, it's a long 2021. Lordship have framed the substantial question.
What about service?
My judgment in page start from
L1, so and so, so and so. Use, return, confuse. Now let us see how does the learned trial court look
Madam.
into the first appellate court.
that point of limitation on page 41.
Simple. Yes, what is that? Item number 52. What is that matter? Oh, not possible. How is it possible to be done? Yes, when do you want? Okay. I won't be taking up any further of this. I'm requesting the chief to give me criminal.
I think the poet will not despair.
Huh?
Advocate will not despair, Lordship.
It's on 6th of May 2025.
That's page 41, the operative part of that limitation code. Issue number.
Mine? Which one? Let me release it. What is this? Huh? T1. RSA. What is this? Oh, yes. That one. That land. Did you find it? So then, think of. Yes, Mr. Samaria, you just excuse us for some time. This matter
Right,
was
no
heard earlier. I will
Otherwise,
take it up.
that is a bit, I have no problem because otherwise a fit case for remand, my lord, because that issue is.
This is a case of remand, but I don't pass an order inside.
Right.
Online. Now, Mr. Sharma, I thought about it in your case. This is, once you have filed that application, which he has no objection, I think the best option is to remand the matter to that effect. Only to that, under order 41 rule 25, keeping the second appeal alive. I think that is the best option, because tomorrow, if the court passes an order to that effect, then in that case, after passing of that order, the court will require, what you call, there might be a question of cross-examination. I think, and this, it would not be proper on the part of the second appellate court to take evidence. Don't you think so? So, in view of that filing and the requirement as per law that there has to be a. Yes. The list this matter on Thursday at 2. I'll dictate it on Thursday. I mean, I'll be getting, after so many dictations, it's tiring. Because I think that day I thought about it after allowing it, that I will remand the matter under order 41 rule 25, keeping the appeal alive and asking the trial court, the first appellate court, to take additional evidence in respect of this and then submit a report. I frame an issue. You just formulate an issue and give it to me on that date. And there is a judgment of the Supreme Court wherein it says when it is a case of boundary, it is required that you should have an order 26 rule 9. You have it? Just get that. And on the basis of that, I will remand it and keep the appeal alive. Then you don't require to file again an appeal. You can very well take on that issue and take it up. Isn't that the provision of Order 21? 21 rule 20. Where the court from whose decree an appeal is prepared has omitted to frame or try an issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred, and in such case shall direct such court to take the additional evidence. And such court shall proceed to try such issues and shall return the evidence to the appellate court, together with its finding thereon and the reason therefore, within such time as may be fixed by the year or extended by it from time to time. So I think this is the proper procedure it should be. So I'll have to frame an issue and then remand it. Yeah, to ask them to take additional evidence by appointing of an amend commission as regards the land. Because the land, if I remember, which was given to me, to the east, north, south. North, south is north is south, east, west. East, west. Now, to the east of the petitioner's appellant's land is a 12-feet road. But at one junction, somewhere, it takes a L shape. And this L shape makes that portion of L shape is a 15-feet road. This is 15 feet and this is 12 feet. So he's not. The only problem with your case is when you came, there is no evidence to the effect on writing that your land, the 15 feet road starts from the road, the main road, I suppose, some Bhachaji or something, or whatever it may be, from there to the Nela Khal or something. It doesn't say. It is being only, you are saying on the basis of implication, on the basis of your sale deed. But the question is, the problem is not that. The problem is only issue is whether how much is the length from that road, from which is your eastern boundary, from eastern boundary to the eastern boundary of the plaintiff's land, of the Mr. Sharma's client's land. That is the only issue. That is the question, isn't it, Mr. Sharma? As to what is the length of the land from the eastern boundary of the plaintiff's, of you are the plaintiff, to the eastern boundary of the defendant. So he also will be eastern. How? East. Isn't it?
Western is a khal.
No. You see, from your eastern, on the east, there's a 12 feet road. Okay. So, in some way or the other, the 12 feet road coincides with the 15 feet road. Okay. So, your eastern boundary, from your eastern boundary, and if you go, his is perpendicularly, it goes, his land, and he has a eastern boundary. So, his eastern boundary and your eastern boundary, although it is a 12 feet road, there is no quarrel, but that is, you have a 15 feet in between, which is with an L pattern. So how much is that L from his eastern boundary to your eastern boundary? Isn't it? No, it cannot be west. East is always east. Mr. Counsel, you have that map. If you go towards the actual north, this actual north, no. You see, normally north, south, east, west is being put like this. It's always north and east, west. In this map, if we see the north, although the north is the east, north is the east, north is the east. Isn't it? So the distance is from his eastern boundary. What is the distance from his eastern boundary to your eastern boundary?
Yes.
That is the length of the load. And the width is 15, is already there. So that is the only thing which is to be decided. Because he is saying that I'm being only given 3 feet of this length of this 15. Is what? You are saying that it is only 3 feet, which should have been more. So therefore, it will have to be seen, the measurement has to be done as to what is the distance from your eastern boundary to his eastern boundary. Am I right, Mr. Sharma?
Yes.
That is the issue.
Yes.
That is the pinpoint. The moment you get there, that is your length of that road. And for that, it might be required because his land is 3 kata 8 shatak or something. No?
That link, that road is my eastern. My
It is not to your eastern boundary. This is to your northern boundary, the road.
northern one.
Yes.
Then automatically comes southern one.
Whose?
Southern one.
No. His land is, his south is your land. East south is your land. You see, I have not seen the file, but I remember by heart. You see, the his land, his boundaries are this. To the east, it is 12 feet. To the south is the vendor's land.
Yes,
To the north, to the west is the Khal. And to the east, where north, there is another land. We are not concerned with that. We have nothing to do. Your land is to the east is some road and Bhachaji. And then to the south is Khal. To the north is the 15 feet road. Didn't it? And to the south is somebody, we are not concerned. So here, therefore, the land is from the east, from your, what is your east? What is the difference between your east and his east? That is, what is the land? Because there is already, because one thing one has to view. That cannot be 3 feet because of the fact his east is 12 feet, starts with the 12 feet. You get the point? No, Mr. Ghosh, kindly appreciate. He's not his east is 12 feet road. Isn't it? It has to have somewhere to you. Yes, that portion. So therefore, it cannot be because of that 12 feet, of which 6 feet is being given by the owner. So therefore, it cannot be that it can be 3 feet only for you. It has to be have the minimum 12 feet. And from that 12 feet, how much is the 15 feet is the question.
Out of 12 feet, some portion is my part, some portion is my third part. Third part.
Of that 12 feet, some portion is 7.5 feet of yours and some 7.5 feet of that other person. So the breadth of this is his road, the 12 feet road, the breadth, not the length, is 12 feet. Understand that? There's no quarrel with that. I think we may have to have a monitor. I get that point. So therefore, that is the only way out. So therefore, one thing is clear. It can't be 3 feet. The El Petan road or the 15 feet road cannot be 3 feet. Has to have minimum 12 feet. It starts from zero, so it has to have 12 feet. Because of the fact that who is not, who is there's already a 12 feet.
yes.
Isn't it? It cannot be. Anyways, this matter again, matter having been heard at length, this matter on 27th, 2025. It has to touch your boundary. No, it has to have a 12 feet. There cannot be a portion. So let us not spoil my ear on this. Let the first appellate court decide on that. Yeah. Hmm. With the other side. You're asking for enhancement. You're asking for enhancement. Oh. What is the issue? Anyways, and take it without the other side being present. When do you want it? Yes, what is your limited prayer? When do you want it? I am not, it is not convenient to me. I won't be sitting, so you can. Yes, Mr. Doctor, you are challenging on what ground? Double benefit. Loss of immunity, it's a death case.
Case has been informed by.
But you have got your money from oil for 7 days.
But on this way, you have evidence. That means that some of the amount is rejected. It is rejected, that has been.
You have put the evidence.
It is
When do you want it?
now the board.
I can't say all these things. These are one MSc appeal, I can very well pick it. This doesn't take much time. Let us have it on 6th of May. At the request of both the parties. The matter stands adjourned to be listed on 6th of May. Yes, Mr.
Madam,
Chairman.
page 41, madam. So, issue number 2,
Page
page
Well-
41, madam. The issue was decided
number 2.
in the operative part,
51.
page 43, paragraph 54.
51. Issue number?
Issue number 2, limitation point, and decided that is contained in page 43.
Whether the suit was
Paragraph
issued for declaration that she is the only issue of so and so and the defendant number 1 is not the firm. Limitation for a suit of this nature is 3 years from the date of accusal of so and so. But not contained in our value. What does the first appellate court?
My lord, page 62, paragraph 23, middle part. Issue number
Yeah.
2.
I think issue number 2 regarding issue I am not intending. This is issue number?
Issue number 2, answered, that is paragraph 23, page 62.
Number 2. I'm not inclined to interfere with the decision arrived by the trial court.
It has been appealed and thereafter, my lord, that decision was tendered, that trial court decision not sustainable.
We'll pass the order. Remand it under order 21 rule 26A and fix the date before the trial court, first appellate court on 14th of May. The appearance disposed.
Okay.
LCR will return. 14th LCR will go na on 28th of May.
Right.
Yes, Mr. Guswami, what are you waiting for? Ah. You want the date? You want the date? No, I can't do it without the other side. Although he was supposed to be there till 4:45, we still have 4 minutes left. No, it's okay. We will have it when? 6th of May? Mr. R. Goswami appearing on behalf of the claimant submits the matter requires an urgent disposal, taking into account. It's very difficult. Because they feel a new judge is going to take it up. I won't be here. So if I was there, I would have fixed it. No, because I have to dictate and then sign also I have to do. So submits that the matter requires an urgent disposal as the claimant is suffering. Is taking into account the above. Let's see on 29th of April. Was of liberty given to the counsel appearing on behalf of the parties to mention the matter for the